Something already handled it. Today's serial number 52.
52.
52. Pertain to the removal of illegal hoardings and flex banners. So several directions are issued by this honorable court. And even today, the hoardings are all put up in front of where the High Court building is spent everywhere. And there's an order passed by this honorable court on 2nd August 2023. If any hoardings report after 3 weeks, it's not. The government has to pay 50,000 deposit before this court and the BB to 50,000.
What do you want?
And there says one acted has taken place. The huge hoarding has felt.
What do you want?
Can be 30 or take it up from the
Tomorrow?
I'll inform the
Tomorrow?
tomorrow.
Tomorrow at 11? Tomorrow in the first half, any case.
Because earlier it should be come in the top of this because of the gravity of the situation.
We'll take up. It is old matter.
Old man, 2017.
So, but what is the urgency? What is the urgency?
So the urgency is that even today, in spite of the several directions, the day yesterday a huge hoarding has fell. The person now is in the hospital and he is almost virtually coma state.
Hoardings of hell.
Hoardings of helmet.
Hoarding.
From somebody taking life.
Yes.
Yes.
It's not like.
Hoardings are put where?
They are not removed, they are not.
Where they are put?
It is near Helan.
On building, on poles, on some
On way.
on way.
Highway.
Highway.
Yes. And now even they are not left even the burial grounds. They are also huge hoarding. There is a direction to remove everything.
So fresh, despite God's order. So can you bring the photographs?
Photographs.
Yes, we have produced all the photographs.
No,
There
you are saying there is a fresh development.
In fact, I have to give my response.
We do not know anything.
So
If you want
produce all
to,
the photographs.
you have to demonstrate on record. So do so whatever you want to do.
Even in the last year in date, we have produced all the photographs.
We can't go on advising you.
Yes. Yes, ma'am. We'll produce, ma'am.
We'll produce it. Tomorrow I will produce.
Tomorrow.
Kindly have it.
Yes.
Produce all the photographs.
Serial number 70, I may be permitted to withdraw the petition, madam.
70.
70.
I appear for the rest.
I've served a copy on it. 70.
Read petition 2271 of 23, learned advocate Miss B.B. Vidyulata. Upon instructions of the petitioner, seeks permission to withdraw the petition. Permission
We
is
memo
granted.
it, sir.
The petition stand dismissed as withdrawn.
We memo it.
She places a memo dated so and so, which reads as ending. The memo is taken on record. The petition accordingly stands disposed.
Public.
What the memo?
At 60.
Seal number 30, madam. Seal number 30, madam. For petition in this case,
Still number?
30, madam. If a petition, madam, can you take up on next week, madam, senior in out of station, madam. Inform to others also, madam.
So what do you want?
Next week, madam. Please, madam.
Next week will not be possible. It will go to 1st August.
Please,
At the request of learned advocate for the complainant, stand out to 1st August.
Serial number 78.
not the place, madam.
78.
Filed a memo for deletion of third appellant as he is not continuing with the course. If there is some urgency, examinations are starting from 15th. Senior counsel Sri Uday Hola is engaged in this matter. May be taken up, priority, my lord.
Which course? MBBS?
BAMS course, my lord. BAMS course.
BMS.
Yes, my lord.
But then number 3 is not signed at Pakalatnama.
Yes, my lord. I have filed a memo for deletion also that is not been put up.
You are deleting.
I am deleting.
Or like 2:30?
Yes, my lord. Right from
It
it.
starts on 15th,
Yes, my lord.
2:30. You, 2:30.
Serial number 32, my lord.
Yes, Mr.
Serial number 67, madam. I am withdrawing with the liberty to file fresh.
67. Why liberty?
67.
See complaint, CCC 637 of
Complaint.
24, learned advocate, Mr. G.R. Ganesh
With the
Rao,
liberty to file fresh.
seeks permission to withdraw the present contempt petition. Submitting a handwritten memo dated 11/7. What is the reader?
Pardon. I prayed for a fresh, with the liberty to file fresh petition.
It is complied with,
Complaint.
complied with.
A2 and A3 are not required in the,
Order is complied with or not? Why?
partly it is complied. Order of this
State is not
honorable
a-
court is partly complied.
State is not a party in this.
That can't be done. Impartial.
So I will withdraw and file fresh.
Withdraw unconditionally withdraw.
file
We'll
fresh-
say that fresh development will give fresh cause of action.
Afresh I will file.
Fresh development in the matter will give fresh cause of action. That much we can say.
Not able to understand. Separately I will file now.
We will only say a line after permitting withdrawal that fresh development will furnish to you fresh cause of action.
Okay.
Learned advocate, Mr. So submits memo dated, handwritten memo dated 11/7/24, which reads as under. Full stop. In view of the above memo, he seeks permission to withdraw the contempt petition. Permission is granted. Paragraph. Learned advocate, paragraph. Submits the reserved liberty be reserved to file the contempt petition. Again, if need arises, it is only to be observed in that regard that any fresh development in relation to subject matter adverse to the complainant may give fresh cause of action to the complainant petitioner. This contempt petition is accordingly disposed. Yes. Yes.
AIL matters. Respondent is encroaching the lake and road minors and constructed the multi-storey hospital. in Sarjapuram.
Either 16th or
Please,
23rd, whenever you want.
any date.
23rd,
16, 20.
23rd.
Serial number 64.
Serial number 32, my lord.
Yes, Mr.
Serial number 64. I am withdrawing the.
Serial number
64.
64. Learned advocate, Mr. Chandranath Hariga, for the complainant seeks permission to withdraw the present contempt petition, submitting on record memo dated 11/7/24. Reading as under full stop. In view of the above memo and the request made, the contempt petition is disposed of as withdrawn.
Serial number 45, my lord. In this matter, my lord, there is a writ appeal in 45, my lord. There's a writ appeal before this honorable court pending for adjudication, my lord. It's sought that this contempt matter may be clubbed with that writ appeal, my lord.
One sec.
Yes, my lord.
So it is contempt 1076.
Yes, my lord.
So what do you want?
To club the matter with the writ appeal, my lord. Both writ appeal and contempt matter are arising out of the same order, my lord.
It was stated by learned advocate Miss, what is your name?
Priya Koshi, my lord. Priya Koshi. Sorry, my lord.
Kushi.
Koshi, Koshy.
For learned advocate Nitin name, that this contempt petition is required to be placed along with writ appeal arising out of the same order.
Yes, my lord.
Full stop. It shall be listed along with writ appeal number
Yeah.
1189 of 23. Full stop. Learned advocate files memo dated 11/7/24. Setting as above. Setting and requesting as above. The memo shall remain on record.
Much obliged, my lord.
Serial number 32, my lord. I appear for the petitioner.
Serial number?
32 here. 32, my lord.
Yes, you want to mention?
Serial number 37, madam. I appear for the appellant in this matter. Serial number 37, I appear for the appellant. I pray for a week's accommodation, my lord. There is some personal inconvenience today.
37 you want time. It will go to 9th August. Yes, anybody? Yes, Mr.
32, my lord.
32.
I appear for the petitioner.
Yes.
My lord,
He's
sir.
appearing for the respondent.
Point number 4, advocate, I am
So,
appearing for.
The senior counsel is not recovered from the heart surgery. So kindly grant adjournment.
So let it go September. This is whenever council is available. We have a good ground towards, but every time we will not be adjourned. So we'll give the long date.
Okay.
This is third time you are mentioning, therefore. It will go to 10th September. In view of this request made on behalf of the writ petitioner that the senior counsel appearing for the petitioner is indisposed health, stand over to 10th September.
My lords, one more serial number at
Please approve. This matter pertains to a PIL against Nandini in the Karnataka Milk Federation. Against Nandini Milk, the price increase which was done by Nandini product by Karnataka Milk Federation. So it came to be filed on 4th of July. The price increase happened on 26th of June 2024. It came to be filed on 4th. I was told on Monday that the office objections have been removed. However, it has not, the scrutiny slip has not come. I urge.
24th.
My lords, one more serial number at 34, my lords. I'm appearing for the petitioner counsel in that matter, my lords. The counsel on record, she has fell sick, my lords. I request for 2 weeks time, my lord, in that matter.
34.
34,
25th July.
please.
My lord, serial number 17, my lord. I'm for 17, I appear for accused.
17.
Yes, my lord.
In 17, I am representing complainant, my lords.
So what do you
Serial
want?
number 17, my lords. I am
Some
representing complainant,
negotiation,
my lords.
pay for time, my lord.
Time,
Yes.
which date? 5th of August. As requested by learned complainant, stand over to 5th of August.
List number 2, serial number 1, Mr. Anil Kumar R.
This is yesterday's matter,
Day before yesterday it had come and.
covered.
That, with regard to office objections, it had come and my lords were pleased to post it to today.
We are studying in BHMS,
BAMS, my lords.
BAMS.
BAMS, undergraduate course.
What is that course? Bachelor of?
Bachelor's pardon?
Bachelor of? What is
Bachelor of Ayurvedic Medicine and Surgery.
Ayurvedic medical surgery.
Please, ma'am.
Who is to give approval?
Let the second respondent, Rajiv Gandhi University, has to approve the
And
admissions.
respond.
Admissions were done, but in terms of Annex D.
So you are so many, how many you do?
biggest-
21, 20,
biggest-
20 students.
20 students, but out of 46 students,
So who is to give approval?
approval, second respondent,
This one, university.
second respondent university, Rajiv Gandhi University.
Why it is not giving?
But so far, no reasons are given, nor an endorsement is given as to why the admissions are not approved by the Rajiv Gandhi University. And where the examinations will commence from the 15th of this month. For these students, the rest of the students' approval is there. These students may kindly be permitted to take up the examination commencing from the 15th. And my lord,
Which
when I,
exam? Which
Biggest
exam?
pardon?
Which examination?
But
Internal.
first year final examination.
First year final.
Final examination. And my lord, if my lords would be pleased to permit me, the Dharwad bench and my lord, before this honorable court, a learned single judge, day before yesterday, but I was pleased to permit the students, keeping open the contentions and subject to the result of the expedition.
That order is there. I'm appearing for students. That order is also.
Hard learned advocate, Mr. Where is the second list? I am not getting second list. Where is the second? Not any other. And it separate. My goodness. Learned advocate Mr. Anil Kumar for the petitioners, who appears, sir? Who are appearing?
But I am appearing for the petitioners council. I am appearing for students, my lord, in the same petition. For
So,
students.
two advocates for petitioners.
Yeah.
Third learned advocate Mr. Anil Kumar and learned advocate Mr. Vivek Reddy for the petitioners. So, first petitioner is the college. Whereas petition number 221 are the students who have sought admission in the course of BAMS in the academic year 23-24.
Yes,
23-24. In the petition number 1 college.
My apologies, my lord. Academic year 22-23 minutes.
22-24.
22-23 minutes.
It is the case of the petitioners that the college has the intake capacity of 46 students, which admitted 26 students for the relevant academic year. However, the admissions are not being approved for the reasons best known to respond number 3, Rajiv Gandhi University of Health Sciences. It is the specific case of the petitioner that they have been already admitted by petition number 1 college and continued their studies. Notice returnable on first August. Learned advocates for the petitioners press for interim relief by submitting that the first year final examination is going to commence on 15th of July 2024. It was submitted that if the petitioners who are already undergoing the studies are not permitted to take the examination, irreversible situation may arise for them. In the facts of the case, therefore, by aid interim relief, it is directed that the course of the studies of all the petitioners, number 2 to 21, in BHMS course,
BAMS.
interjected
BAMS minutes. Sorry, BAMS minutes.
Please take your seat.
Sorry.
You dictate the order.
Sorry.
It really breaks my mind.
I'm sorry, minutes. My apologies. Minutes.
What did you write? BAMS course shall not be interjected in any manner, including in respect of taking examination by them, which shall be offered to them by the college, by the university. It is however clarified that permission granted to the petitioners by this order to appear in the examination shall not create any right or equity in favor of any of the petitioners and shall be subject to final outcome.
God bless you. God bless you. My apologies for the interruption.
No, forget.
I'm sorry.
Moment goes. I know.
I fully understand, minutes.
Take notice for respondent number 1.
Next.
Request for hand delivery of.
Yes.
Request for hand delivery.
Pardon?
My request for hand delivery of the interim order.
Hand delivery. You need not give cinema. Hand delivery of this order is permitted.
This is number 2, Ajay Kumar Patil.
Appearing, my lord, for the petitioner.
To the respond.
Lord, in this matter,
Is that
I
PI?
request for 10 days time because Lord,
this issue is being discussed by the cabinet subcommittee. But if 10 days time is granted, my lord, by that time they'll take a decision since
This is
counseling.
PI?
No, this is relating to my lord, OCI, which is covered, fully covered by the apex court judgment.
You are seeking reservation?
No, no, that is what, no, that is the misleading statement they have made. I am
is
seeking
covered.
for general seats in Hyderabad, Karnataka.
No, not. 371J, blood reservation.
Not a reservation at all.
371J is
I'll
a
clarify
reservation
that.
according
I'll
to.
point out their own seat matter.
No, 1 second.
We'll consider your argument also.
Please, please.
According to us, it is a reservation that it has not been granted in
No.
any of the earlier matters.
So as per the directions of the state court, you are considering this.
Lord, this issue is being
You are
discussed.
considering this.
This issue is being discussed in the subcommittee, my lord. They'll take a decision.
give time. But don't create any adverse situation for them in the meantime.
No, my lord,
Since
thing
counseling
has-
is not,
council is not yet started.
not yet
And
started.
not scheduled also. Not yet scheduled.
The prayer in this petition,
Please.
inter alia, is to set aside the clause number 6, in particular clause number 6.1.
I may just make one submission, my lord. As far as that clause is concerned, my lord, they have even conceded before the division and before my lords on the previous occasion that they are not insisting on that clause. They are not insisting. That is what they have considered.
We have considered with regard
So
to.
then what remains in your
Then,
petition?
my lord, they
Reservation.
are not considering me for Hyderabad, Karnataka, Kerala.
Therefore reservation.
That is.
Not a reservation. According to, I'll point out, I have produced the seat matrix. I have produced the seat matrix along with my IA. It is not at all a reservation.
So what is that?
It is for those who are domiciled in that local area. There are general seats there. For general seats, everywhere they are considering. Hyderabad, Karnataka general seat.
So it is reservation by domicile.
Yes.
It is not. That's why, my lord, kindly see the seat matrix which I have produced along with
That
my
will,
IA.
we have an
And I have
argument. on.
produced.
A foreigner cannot be a domicile.
But would you like to intervention of the court at this stage when they are considering?
My lords?
When they are considering,
Yes.
let us wait.
No, they are not, they have given me an endorsement that they will not consider. I have produced along with my IA.
Now it
No,
is-
they have said.
No,
They have said
My
no.
instruction.
Today's statement of the council of the government that they are subcommittee of the cabinet is
yes.
considering.
If that
What
is a
is-
fresh development, I am not aware. If that is,
Neither we ever nor you are.
please, my lord.
Nobody can aware.
Yes. No, my.
Only they are aware that they are considering.
Yes. Now,
And we rely on them.
yes. No, I would, no difficulty as far as that is concerned, my lord. My only apprehension is, he is asking for 10 days time, saying that the subcommittee of the cabinet is seized of the matter, that they are considering it. In the interim, or if they notify for courts. That is
What?
my difficulty. That is all, my lord, because everything depends on what happens in the Supreme Court tomorrow. Whether need retest will be ordered by the apex court or not. Apex court is still considering that aspect. If retest is ordered, there won't be any counseling in the near future. But if no retest is ordered, the counseling may start day after tomorrow itself.
No.
Saturday, Monday, any day they may notify. So, therefore,
if-
there is urgency. And
Which I haven't let him move.
they have clearly given endorsement saying that I will not be considered under that category. In writing,
A
You are
lordship may
overseas
be-
citizen.
my lords.
They are
Overseas.
I am overseas citizen of
Overseas.
India,
Or
but
foreigner.
I am on facts. I am here in Karnataka. I have studied in Karnataka.
So overseas citizens are not citizens as such.
They're not
No,
citizens,
they are
they're
not
foreigners.
Foreign.
Yes, they're not citizens.
The word citizen is a misnomer.
Yeah.
It is actually overseas citizen of India card holder. The correct,
No, they are essentially not citizens.
certainly not, ma'am.
They are
Certainly
named,
not.
named as overseas citizen.
No, they are known as overseas citizen of India card holder, not as overseas citizens. That is a misnomer.
Card holder.
Card holder.
Yes,
But in any case, they are not citizens.
they are not citizens.
That you agree?
Yes, Apex Court has considered that aspect and said they should be treated on par with Indian citizens. My lord
It is a
has,
different thing, saying it par, but you are not citizen.
yes. So,
But then
once
they are,
we merge with the class of citizens. Once it is said that we should be treated on par with Indian citizens, my lord, we merge with that class. If that class is entitled to a citizen of India who is a resident or a domicile of the local area is entitled to the general seat. Since I merge with that category, I merge with that class, my lord.
the grievance of the petitioners in this petition is about their claim for consideration to admission in the professional courses in different colleges in the state of Karnataka for the academic year 2023-24.
24,
24-25. The petitioners are
Only one petition.
overseas citizens
Oh, yes, overseas citizen of India card.
of India card holders. They claim the benefit of Article 370 small j of the Constitution on the ground of their status as local domiciles.
Local domicile, yes.
Full stop.
I have produced the certificate also.
Full stop. When the petition came up for consideration, learned government advocate, Mr. Mahindra stated that the subcommittee of the cabinet has been seized with the subject matter and the same is being considered by the committee. We therefore requested the court to put off the hearing of the petition by 10 days. Full stop. Request is reasonable, stand over to 24th of
That may be a little too late, my lord, because the counseling, if it come, may I request for 18th or 19th? That is all my request, my lord. If in the meanwhile, if it is not done by 18th, then again it can be
May-
taken
may-
up on
may-
24th.
Are you saying that
No,
council?
we have not scheduled the counseling at all. In the event, if we schedule, let him, permission may be granted for him to move the matter.
Yes, observe, my lord, if the counseling is notified, I can
24.
move the matter.
24. At this stage, learned advocate, Mr. So-and-so, so every end. Express apprehension that if the counseling is notified in the meantime, irreversible situation may arise for the petitioner. Full stop. In this regard, it is only to be, it is observed that in the event of counsel being announced by the Karnataka Examination Authority, it shall be open, it will be open for the petitioners to approach this court by filing interim application.
Please, please,
Obliged. Considered in accordance with.
Yes.
please, 24th, my lord. Oblige. Oblige. Serial number 3, ma'am.
Number 3.
I appear for the petitioner in this matter. My lords, I have granted an interim order on the previous occasion, saying that I should be considered on par with Indian citizens. Already an interim order has been granted in terms of the earlier interim order of the division bench at annexure page 55. In this case, interim order has been granted. According to me, it is fully covered. According to me, it is, but notice has been issued and it has not yet been served. That is what the cause is, not yet served. But I may be permitted to take out notice on the only two counsel, my lord, government advocate and the counsel for the KEA, who just appeared.
Please, Alex.
Yes, please.
For R1.
24th, ma'am, on 24th.
Please.
Please. Sir, funny, sir, sorry, sir.
Number 4. Farah Fatima.
May I please? Oops. This is an appeal by the university against the order of the learned single judge was directed reconduct of the practical examination for the final year students who had taken the examination in July 23. These students' case is that in the practical examination which they took in July 23, the examiners have not individually entered their marks in the prescribed format and therefore it has vitiated. May I request my lords to kindly take page 81, my lords, the format of the page 85. My lords.
On submission. In the main matter and the contempt matter appearing for the respondents in this case, the students have attempted the supplementary examinations in pursuance of the order passed by the learned single judge. Therefore, this writ appeal is rendered infructuous because the examination is conducted and the results are almost out. The appeal
In 4.2 minutes, in spite of there being an order, the university did not implement it, they challenged it. The petitioner, my lords, appeared in the supplementary examination and the writ petitioner has cleared the examination now.
It's respondents
MBBS.
1 to 5
MBBS.
are the students, my lords, who were before the learned single judge.
In 4.2,
Respondents 1, 2, 3, and 5 have since passed out, and to that extent, my lords, the petition has become unnecessary. But respondent number 4, who appeared in the supplementary examination but still failed, would be seeking, my lords, enforcement of this order of the learned single judge, and therefore it doesn't become infructuous.
no, in 4.2, the petitioner.
Respondent number 4, Miss Ariel Ramare.
4.2 has become infructuous.
That will make. In the first matter, my lords, there are two matters.
please. We have appeared, my lord.
They have
Of-
appeared,
of
they have
the-
passed out.
Of the
They have
two,
appeared not pursuant to the order of the learned single judge, but every 6 months there is a supplementary examination. They voluntarily took that supplementary examination and they have passed out. So to that extent, my lords, this becomes unnecessary insofar as response 1, 2, 3, and 5 in the first matter. Respondent number 4, who also took the supplementary examination, has failed, and therefore she would be pressing for the enforcement of this order.
Subsequent.
Lord, only the petitioner number 4, please, she, Lord, that is what the instructions are, that she has not passed. Regardless of, my lord, the learned single judge's order, she has attempted the examination and there she has failed. That is not in dispute. We do not dispute about that. But she has not made an effort to come back to either this court or to the registrar therein, seeking directions or compliance of the orders of the learned single judge. Therefore, my lord, our submission is that this petition is, this appeal is rendered infructuous. Maybe in the
My
event.
land friend,
Please, please.
But if my learned friend makes a statement that insofar as R4 whom he represents is not interested in prosecuting, Lords may record that and close the matter. We have no difficulty.
We may
Only
not be in a
difficulty is this, my lords. Following this order, petitions are pending before the learned single judge who seeks to follow this very order. So your lordship may have to say something about that, because I'll demonstrate that this is a misconceived order, my lords, insofar as the direction.
Please.
And this, the order, my lords, of the learned single judge cannot become a binding precedent on the learned single judge before whom several I'm sorry. Yes.
Please, please.
Lordship, please.
Please.
With just one more request, Lords, that the university is free to urge the issues which have been urged in this writ. Lordship, please. Now, my lords, insofar as R4 is concerned, my learned friend's statement may have to be taken note of.
I may not be in a position to say that on record, my lord, because I have not received instructions on whether she seeks to reappear before of course, it is her right. Please. Please, my lord.
No, my lords, final examination.
They were in the final examinations. I apologize. Pratik Charma.
Nishant,
Nishant.
it's in 4.2. Supplementary.
Supplementary examinations conducted thereafter. February, my lord,
February 2024.
4.
Please.
Is again failed. Yes.
I do not want to contest on that. We do not want to say that she is not interested. We are only saying that, my lord, her rights, let she exercise. We do not want to
We will not seek enforcement of this order. That's all. Because the contempt is preferred in 4.1. Please, my lord. 4, please, my lord. My lord, in 4.1, contempt petition is preferred, seeking enforcement of the order. What I'm trying to submit here is, my lord, that we will not press that.
Final
Actually,
exam.
There's no question of taking her the final exam. him
No,
the
no,
final-
no. She has attempted the final examination, failed in practicals. She has subsequently appeared in the supplementary examination. She
Oh.
has again failed. So therefore, enforcement of this sway her doesn't arise.
Out of, yes, out of the 5 petitioners, it was stated that petition number 4, ADL Lamare, appeared in the final examination, as well as also in the preliminary
Supplementary exam.
held subsequent to final examination. It was further stated by both the sides that the said student has failed in both the examinations.
Yes, my lord.
View of the state of situation obtained in respect of petition number 4, student ADL Lamare, in his case, no further the benefit of the directions of learner signature would not be available to the said student.
Please, my lord.
Full stop. Nor the said students have ever approached the court
Please,
by filing any further proceedings.
they have not filed.
Full stop. Since the students number 1, 2, 3, and 5 have appeared in the relevant examination and have passed out, the court is not inclined to go into the controversy since it is rendered academic. Full stop. It is right that the court will not examine the academic issues. The petition is accordingly disposed of. Appeal is accordingly disposed of, keeping the questions of law which may be arising in the appeal to be open to be agitated in future in appropriate case. Full stop.
Bless.
This stage, learned advocate, Mr. So-and-so for the university stated that other similar petitions are pending before learned single judge involving the similar issue. He apprehended that disposal of this appeal may affect those proceedings. In that regard, it is clarified that the present order stands confined to the parties to the proceedings, and the petitions which may be pending before learned single judge shall proceed in accordance with law. And for both the sides in those proceedings, all the contentions will be open to be raised and agitated. Disposed, the appeal is disposed.
We won't say that.
So this one was for participate final exam and supplementary exam. Not if it is preliminary, then
It is
supplementary.
not good.
It's just one submission, my lords. Your lords have made an order in my writ appeal. Lords have referred to the parties as petitioner / respondent, same number. Lords,
Will correct it.
Lords, contempts do not survive.
Contempt is listed
Yes,
in view of the contempt, separate order or whatever, common order, whatever you pass. The contempt petitioner will not survive any of the disposal of the main appeal.
your lords have made same order in 4.2 as well, my lords, I assume.
4.2 also same order.
Lord.
Writ appeal 1540 of 23. But order will have to be passed.
Yes, my lords, my learned friend appears.
Petitioner,
Students are different.
The student is different, only student, my lord. She has passed in the exam, supplementary.
Why appeal is preferred?
No, I have preferred, my lords, he is the respondent.
Same. We'll check up that.
Great.
Great.
List one, contempt matter, seal number one, Mr. Chandrakant R. Gole.
This covered. Same matter. Covered yesterday it was there. Day, same matter.
No, my lords, this is a different matter, my lords.
It's a different matter.
We
What is it?
It's compliance affidavit
Contempt.
is,
Oh, I see. This is what is about five? Let me go to five. Five is two third. This contempt of today's board, yes,
Lord's compliance affidavit is,
filed.
Lord's, it's ready, my lords, if I may.
Yes. We decided.
Lords, we have considered.
We've just received a copy, my lords. If a short accommodation is,
It's only to consider the representation, my lords. And we have considered that. Page 5 of the compliance affidavit.
The direction passed by a single judge in order dated 8th November 23, while disposing of the writ petition, was to direct respondent to consider the representations of the petitioners within stipulated time. The representations were with regard to releasing of compensation which the petitioners claimed on account of acquisition of their land. So today, when the contempt petition came up for consideration, learned additional government advocate Mr.
Modi
Modi
Nikish.
Kishan filed compliance affidavit dated. What is the date of the affidavit?
It's not filed, my lords. Today I'm presenting this.
10th July 24. Stating that the decision is taken as per the directions of learned single judge. Endorsement oblique decision dated 9/7/24 was produced on record. Copy of the compliance affidavit together with the copy of the said endorsement dated 9/7/24 is made available to learned counsel of the petitioner, Mr. So and so, full stop. The endorsement dated 9/7/24 issued by the competent authority of the respondents marks the compliance of the direction of learned single judge. The present contempt petition does not survive, it is accordingly disposed of. Paragraph, it is clarified that if the complainant has any grievance about the endorsement oblique order dated 9/7/24, it will be open for the complainant to independent proceedings to challenge the same in accordance with law. However, in respect of which, in respect of the merits of which, this court does not express any opinion.
serial number 2 and 3 other, they go along.
2 and 3 same,
Same.
Please, my lords.
identical order.
Seal number 4,
I appear for
Krishna
the,
T.
appear for the petition. Lord, petitioners were working with the Karnataka State Nursing Council respondent, my lord, as D group employees, my lord. They were sent on deputation, my
It's
lord.
returnable on 7th August.
Obliged.
Number 5, Mr.
GM Srinivas Reddy.
Present. This non-compliance of the annexure A order passed in writ petition, page number 9. Representation is given a white page number 13.
7th August, notice.
This PL matters number 6. To Suyo Gerle.
But in this matter, my lord, some appear for petitioners also. We have filed certain documents, my lord, where the government has taken steps to implement the NEP. Now, my lord, they are taking a U-turn and my lord, trying to.
How can we direct the government to follow a particular policy and not to follow particular?
My lord, it is a nationwide, for one nation, one education policy should be there. That was the idea, my lord. In that idea, my lord, already the earlier government has started implementing in phase-wise manner.
Understood.
Now, my lord,
What makes you aggrieved by way of withdrawal? What are the specific aspects which make you aggrieved? Generally saying that
Lord, now,
education policy was introduced and now withdrawn.
Lord,
is no ground.
my lord, it is applicable to entire nation, my lord. Therefore, now, my lord, if a state, my lord, takes U-turn.
Everything
now,
is true and good. but
Only because, my lord,
What
there is
makes you aggrieved? What are the features which you make aggrieved? What are the good features in the policy which is now being withdrawn and makes you aggrieved? You
My lord-
highlight that, otherwise this is too vague a petition.
Yes, my lord. No, the phase-wise manner, my lord, they have implemented. That documents we have placed on record. That has not put up, my lord.
What's okay?
My lord, the already universities have, my lord, into national education policy and they are following it. Now, my lord, the
So the government may have its own valid reasons not to follow.
but my lord, the legitimate expectation, my lord, requires, my lord, and also
Not
the
pointing out what we want.
arbitrariness and, my lord, merely because there is change, my lord, that.
What we want, you are not pointing out, notice returnable. On that day, you.
Please, maybe taken up. With the IEA, my lord, I have. On IEA, we have filed, my lord, for additional document.
I am a additional document, layer for additional language will be considered along with the further hearing of the petition.
Please,
So returnable on 1st of August.
please.
Number 7, green bench matter. So Mohammed Shamir.
For the petitioner, my lord. My lord, challenges to certain notices issued by the KSPCB directing me to deposit interim environmental compensation and environmental compensation.
Notice, same, but
I'll take notice in this matter.
derogate Ms. Vaishnav.
In fact, if I may persuade my lordships, there is a connected matter where there is an interim order which only directs no precipitative steps to be taken.
Karnataka Pollution Control Board. Notice returnable on 25th.
Actually, there is a connected petition where there is an interim order, just which directs the KSPCB not to take any
They
precipitative
are
action.
not going to, they are aware of what is to be done in the.
Number 8, Ravindra Gajaram Kolle.
My lords, I appear for the petitioners, my lord.
Serial number 8 and 35 are identical. In serial number 35, we have filed return synopsis.
8A reserved.
8A8.
My lords, in serial number 35, they have filed statement of objections, we have filed rejoinder. Further, it is supplemented with the synopsis as well, my lords. That all 4 matters can be together.
So we'll not resolve this, we'll keep it on 31st of July.
This
Obliged.
and 35. This may be clubbed with 35.
35 and both to be listed on 35.
My lords, it can be listed on
Wait
3rd
for,
of.
wait for the decision.
No, yes, my lords, I just want to date, my lords, on August 4th if it is.
4th.
Yes, my lords.
4th of
August, my lords.
holidays.
Oh, sorry, I'm sorry, my lord. 5th of August.
5th.
Obliged, my lords.
So we'll receive notice, formal notice.
Yes.
Yes, my lords.
Notice returnable on for
Obliged.
5th August.
Obliged.
Listen, 35 also fresh matter.
Yes.
35, Lord,
That
we have filed
So
everything.
35 to be listed with this
Serial number 35.
7791 of 24 on 5th.
This matter, it was hard for some time and we are directed to file synopsis, written.
My lord,
We have filed.
my lord, serial number 35.
Synopsis you have filed?
Yes.
Written submission and synopsis filed in 35, serial number 35.
My lords, 30,
The same which is reserved.
Yes.
no, my lords, 35 is not,
No, on the last occasion, our lordship said it is
Ultimately
resolved.
Same.
Okay.
Where is the written synopsis? You also file, you want to file?
yes, my lords.
When you will file?
I have filed already, my lords. I
File.
filed synopsis.
Very. You give me.
File ಮಾಡಿ.
35.
Yes, sir, that is,
My lords,
sir, we wanted the synopsis to be filed in the reserved man.
This is the reserved one, 35 is
Not reserved. How can it be on board? if it is
listed
reserved?
today.
Today it is listed na, in the serial number 35.
So it's not listed as a reserve.
It is not listed as reserved, however.
7325 is reserved. Kindly file the synopsis in that. Maybe the same, but file separately.
Seven.
By 16 will be able to file.
Today itself, na.
Today it will be.
Today itself. I
Oh,
said.
you,
My lords, one submission, my lords, serial number 35 may be taken up as the lead matter because in only one matter they have filed statement of objections. That is why, my lords.
we'll consider. Let our thoughts crystallize in the reserved matter.
Grateful,
We don't know what we'll do.
grateful, my lords.
This is number 9, writ appeal matter, Mr. R.V. Deshpande.
Hearing for appellant. This is a delayed.
When it is case. You can. 30th July. Notice written.
Well, I will take
That
notice.
side, KVT has filed.
The serial number I filed KVT, a copy is served yours.
For
In serial number 9 yours,
327.
appearing for
respondent 3 to 7 yours.
3 to 7.
Please.
1 and 2 you are appearing.
Aye.
So they will accept the notice.
Number 10. Appeal by state.
This is a state appeal, my lord. There is a delay of 23 days in filing the appeal. Land that had been gifted by the then Inamda to the government to start a primary boys' school, my lord, and it was being utilized as a.
Why you have filed appeal? Petition is dismissed.
My lord, what has happened is the petitioners, my lord, they are the villagers who had filed the writ petition. Now the occupancy right which was given to, it was gifted to the government. Now, my lord, in respect of the same property, my lord, the occupancy right has been conferred on respondent 6. So the playground which is, which was being used by the children, now, my lord, construction is being put up in that place.
So there is a delay, notice returnable on 1st August.
Apply.
This. Number 11. Mr. Srikanth.
Appeal.
May I please, I'm sorry, my lord, I was not aware of my lord's judgment, my lord.
Is it about?
My lord, this is regarding that senior citizens.
That
Yes,
yesterday.
my lord's judgment is noted marked for reporting. It has not come in the report, therefore I was not aware.
That is it.
Yes. No, I went through your lordship's.
Anything relevant? About?
Yes, Minister. No, Minister. With all respect, Minister, I must say that my lord's judgment is directly following the Honorable Supreme Court's judgment up to paragraph 13. But I am relying on paragraph 14 of the judgment of the Apex Court.
Which is that judgment?
First, let me, my lord has followed Supreme Court judgment, Minister. Listen, this is my lord's judgment.
Supreme Court.
Madam.
You be in Supreme Court.
This is my lord's judgment.
So copy to me, please.
Now, Minister, Supreme Court. ಇಲ್ಲ, ಇದೆ. ಕೊಡ್ತೇನೆ, ಅದು ಇಲ್ಲಿ. The judgment of the Apex Court is here. My lord could kindly permit me to read. In my last judgment, my lord, paragraph 5, page 8.
Of which has been impugned.
No, my last judgment, my lord.
Paragraph 5.
Paragraph 5, internal page 5, that's page 5. My lord's judgment, the bench judgment of the son.
Yes. Section 23 is.
Yeah, now section 23 reads as under, my lord, that is extracted. Then 5.2. In Sudesh Chikkara versus Ramti Devi, so and so the Supreme Court discussed the scope and purport of section 23(1) of the Act. In the case before the apex court, the transfer deed did not contain the specific condition of the maintaining the transfer. Same thing in my case also, my lord, in the instant case. It was observed thus. The Supreme Court observed further, when a senior citizen parts with his or her property by executing a gift or release or otherwise in favor of his or her near relatives and so a condition of looking after the scene is not necessarily attached to it. On the contrary, very often such transfers are made out of love and affection without any expectation in return. Therefore, when it is alleged that the conditions mentioned in subsection 1 of section are attached to a transfer, existence of such condition must be established before the tribunal. This aspect has not been noticed, my lord. This, my lord, could kindly see paragraph 5.5 and 6, my lord.
So the examination in 23 is whether condition is very
The
strong.
court was, the Honorable Supreme Court was pleased to hold, my lord, that the tribunal, the authority has the power to examine the matter, even if it is not, condition is not there in the
Correct. That is paragraph 14 of the.
paragraph 14. But that exactly is my case. And if he passes a wrong order, then appeal is maintainable under section 16. There, my lord, there is no direct decision of the Honorable Supreme Court on that. There's one judgment, the earliest judgment I could lay hands, my lord, is of the Madras High Court. There, my lord, may just pass on those judgments, my lord.
My lord, here the question of fraud and misrepresentation is the word.
Lord, in fact.
Let
the
me complete,
question-
madam.
Please. please.
Board is to be established in civil court.
Whether, my lord, on death of the senior citizen, my lord, his rights would stand exhausted is the question, my lord, before this honorable court. My lord.
My lord, the
I mean,
first
they were
judgment, my lord,
influenced
is,
by the order of the single judge, my lord, learned single judge.
fact,
That-
my lord,
the right of the senior citizen, my lord, is a special right, my lord, and does not, my lord, fall under the ordinary property laws for the legal heir to, my lord, pursue the litigation before the tribunal. That was the question, my lord, before this honorable court, even in the instant appeal, my lord. Now, my lord, hearing the matter on merits, my lord, would not be warranted, my lord. That's my humble submission.
No, we are not hearing merit. We are only how to deal with that part.
Please,
I learn a single judge, just set aside the
please, my lord.
gift deed.
Please.
So that portion we will set aside and rest of the direction will continue. And both the parties will have a right to agitate on the validity of gift deed.
Validity of the gift deed.
Gift deed before the civil court.
Please, that is what.
no, my lord, my humble submission is, the AC order should be restored, my lord.
Which one?
In the writ petition, my lord, the learned single judge was pleased to set aside the order of the appellate
The
authority.
direction will set aside.
Yes,
It will mean restoration.
the AC order will stand, my lord. That will come into picture.
No, my lord.
No,
That-
that's
that
where
would-
the-
That would, my lord, extinguish my right to
When
appeal.
parties are going before the civil court
Please,
in relation to the validity of gift
Please,
deed, there
please.
must be a gift deed. Where is the gift deed? Learned single could not have set aside it while relegating the parties to examine the validity of, to contend the validity of the gift deed.
my lord, here the issue is that, my lord, initially, my lord, the AC, my lord, the tribunal, special senior citizens tribunal, had passed an order in favor of the senior citizen. Subsequently, my lord, the son, my lord, I am the son of the senior citizen. I had approached the appellate tribunal, my lord, where the appellate authority, while adjudicating, while pending adjudication, my lord, the
Gift deed-
senior citizen has passed away.
Gift deed is in your favor.
Gift deed is in my favor. Please. Now, my lord, if the AC court's order is restored, my lord, that is the tribunal's order is restored, my right to appeal itself is extinguished, my lord. Now, my lord, the very proceedings, my lord, would stand vitiated by the expiry of the senior citizen.
Which right to appeal?
Not the division bench of this honorable court, my lord, has already dealt with the issue. Lordship may kindly peruse, my lord.
Good.
I have given a copy, all these judgments, I am aware of.
To appeal against what? You are not agreed by any order.
But certainly, my lord,
Today you are agreed by which order?
my lord, at this juncture, my lord, the very continuation of proceedings, what they are seeking for before the tribunal, my lord, would itself, my lord, does not arise.
Are you seeking continuation proceeding?
Please, they're seeking restoration of AC order.
My appeal, let me make my submissions, my lord.
If that would attain finality, my lord, then my right to appeal itself would extinguish, my lord.
Which right to appeal?
Right to appeal against the tribunal's order.
Which tribunal?
Right.
Which is dealt with by Learner Singh.
Please, by the senior citizens tribunal, my lord. Because if the order is restored, my lord, in the absence of my father.
They have right under section 16. That was the argument.
He doesn't have a right under section 16.
They are going to hold it. Look at the language of section 16.
In fact, I have 3 judgments. Let me complete my submission, then they can.
Yes, please. Yes, let the council complete. We'll
Please.
consider. Yes.
Highly obliged.
First of the judgment, my lord, I could lay hands, is of the Honorable High Court of
That was your argument that 16 appeal is not.
Section 16 applies, my lord. The first judgment is of the Honorable High Court of Madras, my lord. It is in 2014. I have given, my lord, that flag A, my lord, I have given.
There are 10.
That's case is Venugopal. In fact, please permit me to read para 1 also, it's very well written, Mila, para 1. The language is very well. I just wanted to read that.
Which
because I have
paragraph?
that. Indian society has long cherished.
No, which paragraph?
Paragraph 1 minute. Mila, Venugopal's judgment. Mila, Madam, sorry. Second.
Venugopal.
Venugopal, yes.
Paragraph?
Paragraph 1 minute.
1.
Page 6 minute. Indian society has long cherished tradition to respect and protect the elders. It is the pious obligation of the siblings to maintain their parents and grandparents. The great saint Tamil poet Avayar said, Annayam Pitum Munnare Daivam, which means mother and father are the first God known to the children. Until few decades in the past, these traditions, heritage, and moral values were taught in the schools as part of curriculum. Since the children learned these invaluable tenets in their childhood, it was not required to remind them of their obligation towards the elders by making any law to respect and protect them. In recent years, under the guise of preparing the younger generation to compete globally in knowledge sharing and employment, we have gradually removed the moral studies from the school curriculum. On the other side of the coin, when the joint family system was in prevalence, the grandparents, in order to at least while away their time, used to tell the moral stories to the children. Pattai Kadaigal, that is grandmother's stories, played a major role to imbibe good qualities in the children. Now, joint family system has also slowly faded away. As a result, the children hardly have the golden opportunity of learning moral values from the elders also. As a consequence, we have witnessed crimes by juvenile delinquents on the increase. Even the government is forced to amend the Juvenile Justice Care So-and-so Act to treat the juveniles on par with adults in respect of certain heinous crimes. Feeling of togetherness has vanished. Love and respect for the elders have diminished. Some among the younger generation do also forget to maintain their parents. Then, my lord, could kindly turn to paragraph 17 at page 11 minute. During the course of proceedings, I noticed that a plain reading of section 16 of the Act gives an impression that an appeal to the appellate tribunal would be only at the instance of a parent or a senior citizen. It gives further impression that the aggrieved children or the relatives have no right of appeal. This does not appear to be conscious omission of the Parliament. The Parliament would not have thought of differentiating between the rights of the aggrieved parents and senior citizens on one hand and the rights of the aggrieved children and relatives on the other hand. It is too well settled that the right of appeal is a creature of statute, and unless there is a specific provision made for appeal, such right of appeal cannot be readily inferred. If section 16 of the Act receives literal interpretation, certainly it would lead only to an absurdity. For example, in a given case, if the parent is aggrieved with the quantum of compensation going by plain reading of section 16, he can file an appeal before the appellate tribunal. But at the same time, the aggrieved children cannot go on appeal challenging the quantum order. They may have to approach the High Court either under Article 226 or Constitution of India or under 227. Thus, as against the same order of tribunal, there may be two proceedings before the two different forums. This would not have been certainly intended by the Parliament. Then, the paragraph above 18. Since I am of the firm view that missing of the words aggrieved child or relative in section 16 of the Act is only an unconscious omission by the Parliament, by applying the principle of casus omission, it should be held that such a right of appeal is available for the aggrieved son, daughter, relative as well. So to this extent, this judgment is against me. Then my lord could kindly turn to
So it
the
is
next,
available.
holding that the section 16 is available to the children also. Then my lord could kindly see the next judgment I have given. That's my last judgment minute sitting in Gujarat High Court minutes.
Where is it?
Paragraph. Paragraph 10 minutes. In para 9. Okay, they have a copy. Para 10, a bare reading in para 16, 9, my lord is pleased to record the provision. Then a bare reading of the aforesaid provision suggests that though the appeal is available to the appellate tribunal, such appeal can be filed by any senior citizen or parent. By express provision, therefore, the legislature appears to have limited the right to appeal for the limited class of persons, namely senior citizens or parents. Then the next judgment is Naina's case from Bombay High Court. Flag C Miller had given. Ink page 13, paragraph 26 minute. Their reliance was placed on the judgment in Venugopal's case of the Madras High Court. Paragraph 26. It is settled a position of law by catena of judgments that a statute is an edition of the legislature, and the conventional way of interpreting or construing a statute is to seek the intention of its maker. A statute is to be construed according to the intent of them that make it, and duty of the judicature is to act upon the true intention of the legislature. If a statutory provision is open to more than one interpretation, the court has to choose that interpretation which represents the true intention of the legislature. In other words, legal meaning or true meaning of the statutory provision. The statute must be read as a whole in its context. It is now firmly established that the intention of the legislation must be formed by reading the statute as a whole. Then please turn to paragraph 28. Though the learned single judge paragraph 28, man. 27 also I'll read, man. 27 and 28. Same page.
Yes, 27, relevant provisions.
The relevant provisions of this act, which have been quoted, reproduced here and above, therefore will have to be construed harmoniously to promote the cause of a senior citizens under this act. The act is enacted for a particular class of citizens, that is, senior citizens and parents, with an avowed object to provide them maintenance by adopting simple, inexpensive, and speedy remedy. It is the settled position of law that the provisions of a statute has to be interpreted in a manner which will give ultimate effect to the intention of the legislature in enacting it and not to frustrate it. Though the learned single judge of the Madras High Court, in the case of Venugopal versus so-and-so, by relying on the decision of the Honorable Supreme Court in Kannadasan's case and by adopting the interpretive tools, constitutional provisions and statutory provisions as held and observed that the words aggrieved child or relative in section 16 of the said act is only an unconscious omission by the parliament, and by applying the principles of casus omission should be held that in such a right of appeal is available for the aggrieved son, daughter, relative as well. The learned judge therefore with a hope and requested the legislature take note of the said anomaly and rectify the defect in drafting of the section 16 of the said act. It certainly appears that till today, subsection 1 of section 16 of the said act has not been amended by the legislature, and therefore, as of today, it is only senior citizen or the parent, as the case may be, are only permitted to prefer an appeal to the appellate tribunal under the said section. The submission of the learned counsel for that in view of subsection 5, section 16, the appellate tribunal ought to have heard the petitioner before disposing of their appeal under section 6, therefore cannot be accepted. Then the next judgment is of the, again, Bombay High Court minute.
This is by which High Court? Bombay High Court.
Yes,
Bombay.
Bombay High Court minutes, 2024. Paragraph 25 minute at ink page 11.
Now, page?
Ink page 11, paragraph 25.
No, this earlier you read was which High Court?
That's also Bombay High Court minutes.
That was also Bombay.
That's also Bombay. Naina's case.
Now, number D.
This is the latest judgment, paragraph 25. This is, in so far as the contention of the petitioner is concerned, that merely because a remedy of
Where you are reading?
well, paragraph 25, ink page 11.
25. In so far, yes.
In so far as the contention of the petition is concerned, that merely because a remedy of an appeal is not provided to the petitioner, section 16 of the Act becomes arbitrary and illegal is wholly untenable. A legislature provision cannot be struck down on such count in the absence of any substantive ground acceptable in law being made out by the petitioner, so as to assign the provisions to be unconstitutional. The provisions also cannot become bad only because of the petitioner feels so. A right of an appeal is to be conferred by law. The legislature in its wisdom has refrained from providing a right of an appeal except to the senior citizen. In any event, it cannot be said that the petitioner has no legal remedy. Then, Millard, I was just examining the matter. Millard. There is no judgment of the apex court. Then I was going through our High Court judgment. There is one judgment of His Lordship Justice Veerappa Miller, which I had given in the first set, Miller, not this batch, Miller. In the first set, I had given, yes. Fact A, Miller. Paragraph 18, Miller. Sorry, no, paragraph 22 at ink page 20. Flag A of the first I had given to your lordship. 2019, Karnataka 2. Please, sir. Paragraph 22 minutes, ink page 18. Because my lord also has observed on the dharma and all those things. Admittedly, in the present case, gift deed was executed by the fourth respondent under the bona fide belief that the petitioner, being her daughter, will take care of her during her old age. But after obtaining the gift deed, the petitioner has shown her real color and deprived the basic amenities and physical needs to the fourth respondent. Therefore, the fourth respondent filed an application before the Assistant Commissioner seeking cancellation of the gift deed executed by her in the favor of the petitioner. The contention of the counsel for the petitioner that there must be a condition in the gift deed to take care of thereof cannot be accepted. If such contention is accepted, then the very purpose of enacting the act by the legislature and introducing section 23 and 24 in the act would become futile. That is not the intention of the legislature while enacting the act. The main object of the act is to provide for more effective provisions for the maintenance and welfare of the parents and citizens. Then paragraph 23 minutes. In the case on hand, the properties were divided among the petitioner of fourth respondent. Then your last may proceed to the last 5 lines. The right of appeal, my lord could get it means. The right of appeal under section 16 is limited to senior citizen or parents or guardians only. Only then, only they can be treated as agreed persons. Appeal from by son, daughter, daughter-in-law, grandson and granddaughter against whom the order is passed by the tribunal is not maintainable. This was taken in appeal, which my lord friend just now relied upon. The unreported judgment minutes, writ appeal, the flag C I have given. That's hello, Karadi. Yes. I went through that entire judgment. Your lordship, take my word. Nowhere section 16 is referred to. What is referred to is from para 7 is only on section 23. If there is section 16, I would not refer to His Lordship Justice Veerappa's judgment. Paragraph 7. That is ink page 7. In the instant case, deceased respondent for was the mother of the appellant had executed the gift deed dated 8/7/15.
Paragraph 7.
Paragraph 7, Miller of the unreported judgment, ink page 7.
The reading of the order.
Judgment of His Lordship Justice Alok Karadi.
Justice Alok Karadi.
Yes, please. Page 7, in paragraph 7. Miller.
Page 7, paragraph 7. There is no page 7.
I'm sorry. Sir.
In compilation.
In the first set I gave this, yes. There it is. Flag.
In the instant case.
Your Lordship, in the instant case, deceased respondent for was the mother of the appellant had executed the gift deed dated 8/7/15. The aforesaid gift deed does not contain any stipulation with regard to maintenance of the deceased respondent for. The relevant extract of the gift deed is reproduced here. Then paragraph 8. Thus, from the perusal of the relevant extract of the gift deed, it is evident that the gift deed does not contain any condition that the transferee, namely the appellant, shall provide the basic amenities and basic physical needs to the transferor. On the other hand, gift deed has recorded that the appellant has taken care of respondent. Respondent for has expired during the pendency of the appeal. In the absence of any stipulation in the gift deed with regard to the maintenance of respondent for, the Assistant Commissioner had no authority under section 23 of the Act to declare the gift deed to be void. However, the aforesaid aspect of the matter has not been appreciated by the
In conflict with that Bombay.
section. No, Bombay, I am placing reliance only on section 16.
No, about the requirement of condition that it is.
Yes, true. So
is
section
gone to apex
20
court.
section 23 Miller does contemplate that there should be a condition. Then Honorable Supreme Court in Ramti Devi's case, that is Sudesh Chikara, which my lord was also pleased to follow in the bench ruling minutes. That has been examined, Miller, that issue. Paragraph 12, 13 and 14 are relevant.
Correct. Now let us go to impugned one.
Impugned?
In our case.
Please, sir.
What is, to recollect what is held by learned.
Paragraph 2 minutes. Her, she, so and so, and a senior counsel appearing for the petitioner, Shripati so and so. The para 3, the petitioner respondent number 2 are siblings. The 2 are children of one P. Krishna. P. Krishna, during his lifetime, had executed a gift deed dated so and so, alleging that he was not taken care by the donee of the document, had knocked at the doors of the Assistant Commissioner. The Assistant Commissioner allows the application in favor of the father and directs resumption of the property by cancelling the gift deed. This was called in question by the other brother before the Deputy Commissioner on several grounds. Both had knocked at the doors of this court in WP number so and so. This court on 24/8/23 disposed of the writ petition on the following submission made by both them. they were permitted to both agitate the matter before the DC. After which the deputy commissioner appears to have taken the proceedings and set aside the order passed with the assistant commissioner on the score that the gift deed did not contain any condition that the donee would take care of the donor for the father to allege that it was the product of fraud or misrepresentation. What happens in the interregnum is the death of the father on 14/7/23 during the pendency of the proceedings, but before the order is passed with the deputy commissioner. Section 23 of the Act is unequivocal that it is rendered for the protection of the senior citizens to knock at the doors of the appropriate authority, calling the gift deed or otherwise. The challenge was made. The challenge was successful, but the father could not bear the fruits of challenge as he dies during the pending proceedings before the deputy.
This appeal was filed by whom?
My brother means.
So it was not maintainable.
According to me, it is not maintainable.
But then today, are we supposed to go into that question?
No, that order of the AC has to be sustained. The learned appeal cannot be maintainable. If he is agreed by the order of AC Miller, he has to go before in a writ form.
No, but is it necessary to decide that question?
Yeah, in the instant case, it is necessary. The reason is, after the order of the AC Miller, my father executed the will. Admittedly, my father expired during the pendency of the matter before.
But he has not filed appeal.
He filed an appeal.
I filed an appeal. That's
My
before the
brother
deputy
filed an
commissioner,
appeal.
The
The present
senior
order of
citizens
the
appellate tribunal.
Then Mr. On that ground also, the entire order will go. The appeal was incompetent.
his appeal was not competent.
My lord, there is a decision of this honorable court, a reported decision after having referred to catena of decisions, my lord. I'm not equipped with the decision right now, my lord. I can quote the number, my lord, please. Writ petition number 147056.
Honest single did not advert to that aspect.
No, Minister. No.
Why?
No, he says, both of you are at liberty
It's
to.
already settled, my lord.
So you are for Lokesh.
Please, regarding maintainability, my lord.
So learner single is not gone into us.
No, he has
Not
not.
gone into it. But the law is already settled.
We can at this stage can go. It's a pure question of law.
Not, and there's no.
We
pleading
can say
to
that the
effect.
the proceedings before the tribunal itself were not competent. Because no appeal could have been lie at your instance.
My lord, appeal is very much maintainable, my lord. This honorable court, the single judge of this honorable court, my lord, there's a reported judgment of this honorable.
Any judgment you want to cite, otherwise will reserve for judgment.
No, my lord, I would, my lord, kindly, my lord, accord some time so that I'll come with the judgment.
Come with judgment.
Please, please, please.
18.
And there's no pleading to that effect, my lord.
No, it is.
I mean, the maintainability is not being questioned in the appeal, my lord. There's no averment.
But if the council is raising that question,
Please,
it's pure question of law.
please, my lord.
Rising from section
But
16.
it's not under challenge, my lord, in the instant appeal. There's no single averment to that effect, my lord, regarding maintainability.
We'll hold
It's
this.
very much
Arguments are not necessary for raising is pure question of.
Please, my lord, I'll come with the judgment, please.
You, in the meantime, you file both of your synopsis and give judgment.
Grateful.
Then
Yes.
we'll.
Please,
consider.
please.
18th.
Lord, kindly on 20th.
Yes,
Saturday. Lord, on 21st, my lord.
That is also already 23rd.
Grateful.
23rd.
Please,
Much grateful.
intermodal to continue. I think last time you
Out
said
to-
until further.
Send out to 23rd in order to enable learned advocate with respondent, Mr. So-and-so, to prepare his case further. Full stop. In the meantime, parties may submit their synopsis of submissions in writing.
Please.
Let for the appellant's counsel. Lordship asked a very pertinent question whether section 95, the IBC has come into force. This is a matter where the proceedings were initiated against the personal guarantors of a corporate debtor. But your lordship wanted to know section 95 has come into force. But I will streamline the entire argument in 2 minutes on a very simple note, because much of the arguments are addressed as if we have initiated the insolvency proceedings against a partnership concern. That is the impression given by my learned friend. That is not correct. I will take your lordships to 5 or 6 sections and will not streamline the entire thing. But section 7 of the act deals with section 7. Section 7, insolvency proceedings, initiation of the corporate insolvency resolution process by financial creditor, that is by the banks, I'll simply banks against a company. Now the financial creditor is defined as a company, but under the act, it's basically financial creditors are always under the act for this purpose is a company. 8, my lord, insolvency resolution by operational creditor, that is by supplier of the goods and services to the company. But this is where the insolvency proceedings are initiated against a company. Now, I take your lordships to the section 522, my lord, 5 subsection 22. But this is where we have initiated the proceedings. Kindly similar section 5 subsection 22. Personal guarantor. Lordship got it? This one. Personal guarantor means an individual who is a surety in a contract of guarantee to a corporate debtor. Now, corporate debtor is basically a company, because that is also defined under the act. Corporate debtor is defined under section 3 subsection 8. Section 3 subsection 8, Miller. Corporate debtor means a corporate person who owes a debt to any person. Now, corporate person is defined under section 3 subsection 7, means a company as defined under section 2 subsection 20 of the Companies Act 2013, a limited liability company as defined under section 2 of the limited liability partnership, so and so, so and so. So the entire gamut of section 7, 8 read with 522 is always against the company. Now, your lordship wanted to know whether insolvency proceedings can be initiated against individuals. That, my lord, hitherto there was no provision to initiate insolvency proceedings against individuals. The only exception is you can initiate proceedings against the personal guarantors of a corporate debtor. Suppose company owes money to financial creditor, like a bank. XYZ executes a personal guarantee to the loan. Against that personal guarantor, now because of the notification issued by the central government, insolvency proceedings can be initiated. But that notification, your lordship get at page number 701, volume number 2. Apart from the company, which I read out at section 7 and 8, for the first time, it is slightly expanded because the corporate guarantors, personal guarantors of a corporate debtor is included, 701. In exercise of the powers conferred by section 1, subsection 3 of the IBC, the central government hereby appoints the first day of December 2019 as the date on which the provisions of the said code only in so far as relate to personal guarantor to the corporate debtor may come into force. Section 2E, section 78, 94 to 187 and other provisions. Now, I have initiated the proceedings under section 95 of the Act, page number 100 may kindly be seen. Page 100 in volume number 1. Page 100, volume 1. that the present application has been filed by the financial creditor applicant herein against the personal guarantors of the corporate debtor, namely Manyata Infrastructure Development Private Limited under section 95 of the Insolvency Code, read with section 7.2. Who are the parties to the petition? Kindly similar page 95.
Your personal guarantee
Yes,
of corporate debt.
yes. Personal guarantor of a, now the loan was borrowed by, the arrangement was like this. Under several,
Not borrowed by corporate debt. Was it?
yes, that, there, my lord, my learned friend has an argument, I will clarify in 2 minutes. Now, there was a joint development agreement with the company and also partnership concern together. We paid about 185 crore and all that. Out of that, there is a single joint agreement between myself and the company and the partnership concern.
Myself
Where,
means,
pardon, my lord?
myself means.
The myself appellant, I'm sorry.
Appellant.
I am the developer, they are the supplier of they are the landowners. Now straight away, my lord, without much, my lord, delay, I'll take your lordships to the loan agreement. That makes all the difference.
Between yourself and the partnership firm.
Partnership concern and the company. So far as the petitioners are concerned, my lord, there are 2 entities. One is a company under the Companies Act and also partnership concern. Now what they did is together they executed a loan agreement where out of 185 crores, 40 crores was treated as a loan, refundable within a period of so date. And the triggering point was also, my lord, established. What I did is I issued a notice to the partnership concern, also to the company. Against the company, 7 and 8 proceedings are pending. Your lordships are aware now, corporate debtor. So far as that partnership concern is concerned, since all the partners are also individual personal guarantors to the company, I initiated section 95 proceedings. Now what they've done is the very filing of the 95 petition is challenged. It did not go before the NCLT. I'll come to that later. But all these questions can be answered if we see the loan agreement, which is produced by me in 685. I am not filing the insolvency proceedings against the partnership concern. I'm only using the notification issued by the central government that you can file insolvency proceedings against the personal guarantors of a corporate debtor. Now, kindly see 685, my lord. In that, my lord, Manyata Infrastructure Development Private Limited is a company. $685, your lordship. Yes. Now, Manyata Realty is a partnership concern. They executed the agreement in favor of the appellant before lordship. Now, the appellant before lordship has taken a new avatar because the name is changed. Now, this agreement says.
Who is the appellant? Buoyant Technology.
Yes, my lord. That was my predecessor. Now, kindly see, my lord, 687.
687.
Yes, ma'am. 687. This is the agreement. The parties here to agree that out of rupees so and so, but paid by the developer, that is myself, to the owners, that is the respondents, under the memorandum of understanding principle, a sum of rupees 40 crore shall be treated as an interest-bearing refundable deposit from the second party to the first party, and thus only a sum of rupees 143 shall be treated as interest fee refundable deposit paid under the said memorandum of understanding as a principal agreement. So the sum and substance, your lordships are aware that out of 183, 43 is treated as a loan, repayable loan. As the said 40 crore, advance having been treated as interest-bearing refundable deposit from the developer to the owners with effect from 1st January 2011 and shall carry a simple interest at the rate of 24% per annum, so and so, so and so. Now I'll take your lordships to the next page, 688. This is very important. This is a joint agreement. But I'll repeat, this is a joint agreement between the company, the partnership concern in favor of the appellants before your lordship, appellant before your lordship. In the event of failure on the part of the owner in complying with the conditions precedent in terms of clause 2 before 31st March 2013, then in such event, the second party shall.
Where you are reading?
Page 688.
688, but where?
Yes, this is the joint liability.
Which paragraph?
Paragraph 5, my lord, paragraph 5. In the
Disagree.
event,
In the event, yes.
in the event
Yes.
of failure on the part of the owner, that is the respondent if before lordship, in complying with the condition precedent in terms of clause 2 above before 31st March 2013, then such an event, the second party shall become entitled to seek repayment of the amounts treated as interest-bearing refundable deposits. Second party is the appellant before lordship. Under this agreement, forthwith, without any further delay, and the owner shall be liable to repay forthwith to the developer the entire sum of rupees 40 crore along with interest due and payable as on that day. Kindly see the owners. My lord, again, I'll trouble your lordship to go back to 685. The owners are Manyata Infrastructure Development Private Limited and Manyata Realty. Now, my contention is the partners of Manyata Realty stood as guarantors to the corporate debtor, that is Manyata Infrastructure Development Private Limited, all the partners. That is why in the petition under section 95, I made all the partners of Manyata Realty as a parties. That your lordship got page 100. Page 100 may kindly be seen.
108.
Page 100. Page 100, volume 1. This is the petition I filed based on 100, I'm sorry. 100. This is a petition which clearly says that the present application has been filed by the financial creditor applicant herein against the personal guarantors of the corporate debtor Manyata Infrastructure Development Private Limited under section 95 of the IBC. Now kindly see who are the parties respondents in that petition. 95.
Yes.
95. The respondents may kindly visit page 95. Manyata Realty, the company is not a party. That is the partnership firm represented by 1, 2, 3, 4, 5, 6. All these are partners. Therefore, these persons are the personal guarantors to the corporate debtor, that is Manyata Infrastructure Private Limited, under the agreement. The entire argument is this loan agreement is not a personal guarantee executed by the personal guarantors on behalf of the company. That is the only argument. My submission is we are not initiating the insolvency proceedings under section 7 or 8 against the partnership concern. No, that has not come into force till today. What has come into force? Therefore, the answer to your lordship's question is whether section 95 has come into force. The answer is it has come into force only insofar as the personal guarantors to a corporate debtor. The personal guarantor here is the partnership concern represented by all the partners, and the corporate debtor is Manyata Infrastructure Private Limited. The agreement is joint, a single inseparable agreement. Both are liable to pay. Now, section 5, subsection 37 of the IBC adopts the Partnership Act, Indian Contract Act, etc. Now, kindly similar 5, section 37. But I apologize. 3, section 3, subsection 37. Subsection 37 of section 3, my lord. Yes. Words and expressions used but not defined in this code, but defined in the Indian Contract Act, Indian Partnership Act, the other acts, my lord, may not be relevant, shall have the meanings respectively assigned them in those acts. So by some sort of a incorporation by legislative incorporation, they lifted the provisions and incorporate. Now kindly see page 1, section 126 of the Contract Act, which defines the contract of guarantee the other day. Right? not 126. A contract of guarantee is a contract to perform the promise or discharge the liability of a third person in case of his default. The person who gives the guarantee is called surety. The person in respect of whose default the guarantee is called the principal debtor, and the person to whom the guarantee is given is called creditor. A guarantee may be either oral or written. Now, there is a, now, my lord, under the IBC code, there is no format for guarantee. There is no separate format. Therefore, 685, clause 5 specifically says, if I demand the money, both of them are liable to pay. The company has failed to pay the amount. This is an established fact. Therefore, proceedings under section 7 and 8 are pending. Now, so far as the personal guarantors, that is the partnership is concerned, they are liable to answer under section 95. Now, what happened in this writ petition is, the real grievance is the very registration of the petition under section 95 of the Act. The opening paragraph in the writ petition is being aggrieved by the administrative act of receiving the petition under section 95, the writ petition is filed. Now, the triggering point, if at all, is moratorium. The moratorium is time bound because the Act itself clearly says the time bound is about 41 days, that's all. But I will just read and I will not, under the Act, the overall provision is section 97(3), the moment a petition is filed, NCLT directs the board to name the resolution professional within 7 days. Then 97(4), board to nominate the resolution professional within 10 days. Section 99, resolution professional should submit the report within 10 days. Thereafter, NCLT to consider the report within 14 days. Totally, the moratorium will be there only for 41 days. Thereafter, the NCLT may continue or may not continue because the report of the resolution professional is not binding on the NCLT. Now, the question is, the petitioners wanted the entire powers of the RP to be exercised by this honorable court. They want the powers of the RP to be taken over by this court to decide whether there is a guarantee or not, whether they were the personal guarantors of a corporate debtor, whether the limitation aspect, all these things, let the RB consider within period of 10 days. That's all. And the moratorium will continue only for 41 days. Unlike, my lord, the 7 and 8, here the moratorium immediately kicks in. That is the only contention. Therefore, my submission is, the answer to your lordship question is, yes, 95 is coming to force, only insofar as the personal guarantors to a corporate debtor. Now, both the corporate debtors and the personal guarantees have a single indestructible agreement. They are liable to pay. I have initiated the proceedings only against the partners who stood as a personal guarantor to Manyata infrastructure. So far the infrastructure is concerned, I have not initiated 95 proceedings. This is all. Now the argument is that I have initiated the proceedings against a partnership concern, therefore I have to go before the DR. That has not come into force. Against the partnership concern, it is not come into, only against the personal guarantors, and I filed section 95.
I'll just take only 5 minutes. In fact, my lord, the confusion that was created before, my lord, the learned single judge was in fact rightly understood. My lords, may I just take your lordships to the judgment and the challenge? My lords, may kindly have page number 19. Page number, my lord, 29. Paragraph number 5. My lords, may kindly have page number 29, paragraph number 5. My lord, if I read these two paragraphs, my lords, in fact, the learned single judge also rightly understood, my lord, but at the time of adjudication, my lord, there is an error, my lord. That's the reason we are here. Kindly, my lord, allow me to, my lord, just read paragraph 5. The learned senior counsel so-and-so, representing the petitioners, would in unison submit that the court does not relate to insolvency resolution of individuals and partnership firms. The jurisdiction of the respondent company is to approach the debt recovery tribunal or debt recovery appellate tribunal. Since no insolvency resolution of individuals and partnership firms are brought under the ambit of the code, the only exception that code projects is that the personal guarantor to the corporate debtor only can be brought under section 90 of the code and thereby conferring jurisdiction upon the tribunal. Since the petitioners and directors in the other two petitions are not personal guarantors of the corporate debtor, nor the petitioner's firm, a corporate debtor, cannot be brought under the code, and consequently the petition filed under section 95 of the code, it deharsed the jurisdiction and therefore would submit that the petition be allowed and the arbitration proceedings be permitted to continue. That paragraph number 6 was our argument, which is rightly extracted. Per contra, both the learned senior counsel representing the respondent company would again in unison contend that though the petitioners are not personal guarantors by name, by their conduct and assurances given to them in the memorandum of understanding, they step into the shoes of personal guarantor, and therefore the petition before the tribunal would be maintainable is the submission of learned senior counsel so and so. My lord, I stop here.
Your submission.
Yes, our submission. Now, my lord, I pause here for a while, my lord, and I'll just clarify in 1 minute. My lord, there is no doubt that insofar as the partnership firms, the code is not yet notified. The IBC is not yet notified. There is only one notification, my lord, which has come into force where the code is notified in respect of personal guarantors to the corporate debtors. Now, my lord, if we have to proceed, my lord, that is page number 100. In respect of, my lord, personal guarantors to the corporate debtors, the code is notified. And the jurisdiction in respect of personal guarantors is also, my lord, NCLT by virtue of section 60. Because, my lord, otherwise, if it is individuals and partnership firms, the jurisdiction to bring IBC proceedings is, my lord, the DRT, Debt Recovery Tribunal. Because, my lord, national company, the basic idea behind, my lord, making DRT as a jurisdiction was that National Company Law Tribunal will only deal with companies. It will not deal with, my lord, any other entities. Therefore, the jurisdiction in respect of insolvency process was conferred upon DRT, and that part is yet to be notified. My lord, these are all admitted facts. We are, my lord, we stand with learned senior counsel, my lord, on the other side for these submissions. That is, in respect of individuals and partnership firms, the code is not yet notified. Only in respect of personal guarantors to the corporate debtor, the code is notified. And if we have to bring any action against the personal guarantors, we have to go before the National Company Law Tribunal. Now, what we have done, my lord, we are calling somebody a personal guarantor. That's all we have done, which is incidentally a partnership firm. Now, my lord, in fact, while bringing a petition against a partnership firm and its partners, we are not, my lord, proceeding against them in respect of a partnership debt. We have, my lord, placed the partnership firm and the partners thereof on the, my lord, platform of a personal guarantor. Because, my lord, as my learned friend read, whether they stood as personal guarantors or not to the corporate debtor, my lord, is the question to be thrashed out by the NCLT. This is all, my lord, the controversy is. Now, they came before, my lord, the writ court and said, no, this petition appears to be against the partnership firm. Therefore, the filing of it itself before the NCLT is void. Kindly now, my lord, see page number 31, my lord, the question which was framed by the learned single judge. The entire issue, my lord, was wrongly, my lord, conceived is our humble submissions. My lord, page number 31, paragraph number 8 of the order of the learned single judge. I have given my anxious consideration to the submissions made by the respective learned counsel and perused the material on record. In furtherance thereof, the only issue that falls for consideration is, my lord, this is what, my lord, we find fault with. Whether a petition against a partnership firm or its directors is fileable or maintainable under section 95 of the IBC before the NCLT tribunal. My lord, the answer is a clear no. Yes, we cannot. This was not, my lord, the controversy which, my lord, we, my lord, debated before the learned single judge. We only said we are not filing it against the partnership firm. Neither are we filing it against the individuals. We are only filing it against the personal guarantors to the corporate debtor. Incidentally, that personal guarantor is under the hide of a partnership firm or a partners thereof. Therefore, if a question has to crop up before the appropriate authority, whether they are, can this personal guarantor, can the partnership firm or the partners thereof be considered as the personal guarantors, etc. This thrashing out had to be done at the first instance by the RP, and at the second instance, after the report of the RP, the NCLT, my lord, the adjudicating authority, by exercising its jurisdiction under 100. This is all it is. Now, the learned single judge, my lord, would say that a presentation of the petition itself could not have been accepted because under a misconception that we mistook DRT as NCLT and went there, which was in fact not correct. We clarified it sufficiently. No, we did not mistook DRT for NCLT. We went before NCLT, particularly being conscious of the fact that we could not have gone before the GRT because that party is yet to be notified. We went consciously before the NCLT by placing them on the pedestal of a personal guarantee. Now, if an argument has to come up tomorrow that, no, we are not the personal guarantor, it's an illusion that is created. RP will not, my lord, will first hear them because that particular hearing is provided under the IBC itself. RP, my lord, the judgment of Jivraj Ka, my lord, in detail deals with it. And thereafter, RP, my lord, within a fixed time, my lord, will submit a report before the adjudicating authority. Adjudicating authority, if comes to a conclusion, no, this is entirely an illusion. They are not the personal guarantor. The documents relied to show and project them as personal guarantor itself is not a liability agreement. This argument that there is a deemed guarantee by an import of Contract Act and Partnership Act, etc., are all cannot be accepted. All these judgments will have to be given by the NCLT. But now, because of this judgment of my lord, the learned single judge, there is one more stage of scrutiny of my lord, acceptance of petition has been created at the writ court. This is all, my lord, we are aggrieved of. Now, my lord, in this, my lord, background, may I just read only one paragraph of my lord Jivraj Ka. My lords may kindly have, my lord, the judgment of Jivraj Ka. My lord, I have already placed it. Jivraj Ka, my lord, I would read for a simple reason that Jivraj Ka, my lord, culls out all the relevant portions of, my lord, section 95, 94 onwards, because that was what the challenge before the Honorable Supreme Court. The Supreme Court, my lord, bunch of petitions were filed on the count that reported version. My lords, I have produced, my lord, I am sorry, my lord, I have produced two sets. One is the reported version, which is, my lord, reported in SEC, and also, my lord, the version of the judgment directly from the Honorable Supreme Court archives. My lords may kindly have it, my lord, have the judgment from the Honorable Supreme Court archives, my lord. I think, my lords, I was referring to that.
I have arranged it in my own way. Where is judgment?
Paragraph number 51, my lord. Paragraph number 51 of Jivraj Ka. My lord, paragraph number 51. The duties of resolution professional in a process under Chapter 3 of Part 3 are contained in Section 99. The resolution professional is required firstly to examine the application within 10 days of appointment. Secondly, they may require the debtor to prove that the repayment of the debt which is claimed to be unpaid by the creditor has taken place. My lord, this opportunity is given. All these arguments, my lord, that no, it's an illusory petition, etc., the debtor can keep it before the. Kindly, my lord, then allow me to read section 53, my lord, paragraph 53.
Summation is in paragraph 86.
Yes, my lord. Paragraph 53 also, my lord, says paragraph 86, my lord, clinches. Paragraph 83 also may be, my lord, slightly important for the reason that, my lord, paragraph 83 reads, before concluding, it would be necessary to deal with two incidental submissions which are heard during the course of hearing. It is sought to be urged that subsection 2 of section 95 indicates that an application under subsection 1 can be initiated only in respect of partnership debt, which is owed to the creditor. My lord, this partnership debt was, my lord, the important aspect. We are of the view that this is not a correct reading of section 95. Subsection 1 indicates that the creditor may apply either by themselves or jointly with the other creditors or through resolution professional to the adjudicating authority for initiating IRP. Subsection 2 provides that in a situation where the creditor has applied under subsection 1 in relation to a partnership debt, the application may be filed against A, any one or more of the partners of the firm, B, the firm. The provisions of subsection 2, in other words, cannot control the ambit of subsection 1 of 95. Now, my lord, it is demystified. It is not just the partnership debt. It could also be any other liability of the partnership firm or the partners, which could be, my lord, even a personal guarantee. Then as my lord rightly said, my lord, 86 clinches.
So 95 one is wide enough,
Yes.
not confined by subsection 2.
Yes. Now, my lord, the only, my lord, otherwise, if, my lord, that interim moratorium was not there, then, my lord, I don't think, my lord, the petitioners would have come before the High Court. The only, my lord, triggering point, as my brother said, is that till the RP decides and till the adjudicating authority decides, which may take, my lord, few days, my lord, it's not even few weeks, few days, then the interim moratorium comes in. The interim moratorium, my lord, is, my lord, it's quite, the rigor of interim moratorium, my lord, is quite harsh. That is the reason, my lord, on this count only Jivraj ka petitions were, my lord, filed before.
So when RP considers this aspects.
Yes.
In the subsequent stages.
Yes.
Whether time limit is statutorily fixed for that purpose.
Yes.
What is the
His
time?
benefit.
That is for his benefit, my lord.
No, any time limit is there in the.
Yes, my lord, 10 days. Yes, my lord, that's what, if your lordships could kindly see, my lord, paragraph number, my lord, 53, for a moment, my lord.
53 of this.
This judgment, my lord, paragraph 53.
Yes.
Of this judgment. The resolution professional is required to examine the application and to ascertain two things. Firstly, the application satisfies the requirement of section 94 or section 95. And secondly, the applicant has provided the information and
within 14 days.
Yes, 14 days.
Total period.
Yes. And by virtue of section 100, my lord, totally, my lord, it cannot exceed 41 days. Within 41 days, my lord, the admissibility or otherwise of the petition has to be decided.
41 days.
Within, in fact, my lord, all put together, my lord, the time that would be consumed by the RP, the time that would be consumed by the adjudicating authority, all these things will happen, my lord, within, my lord, the outer limit of 41 days. And it could happen much before also. Now, my lord, the set of petitions before the Honorable Supreme Court was precisely on this ground, that when in respect of section 7 petitions, in respect of section 9 petitions, the moratorium doesn't come in automatically. We are heard, principles of natural justice are followed, and the admission comes in later. Only after the admission moratorium comes. But in respect of section 95 petitions, the moratorium happens immediately without we being heard. Therefore, it takes away the fundamental rights. It has very rigorous consequences, etc. Therefore, it is violative of, my lord, the constitution was the argument. The Honorable Supreme Court, my lord, in the conclusion said it is not violative, it is rather advantageous to the debtors. And in any case, there is no violation of principles of natural justice because the time limits have been fixed. Time limits have been fixed. And my lord, my last submission is, did we do this as a surprise to, my lord, the cost of repetition? I would make, my lord, this one line of submission. My lord, before a petition of this nature is being filed, my lord, a Rule 7 notice has to be issued. Much prior to that, such a notice was issued. And we, my lord, stacked all these arguments, all these contentions of ours and why we are treating you as a personal guarantor, though you are a partnership firm, etc., etc. Everything was told. It was told to them in advance because, my lord,
Before 95 application.
yes, my lord, before, without which notice, we can't even, my lord, file that petition before the NCLT. It is a statutory, my lord, requirement. We would have given this notice and they have replied to that notice. My lord, if they had such, my lord, a thought process that we are trying to take them to NCLT and there will be a moratorium, they could have taken other measures, my lord, which are available to them under law, which they did not do. My lord, having not done that, coming to the writ court, my lord, we find fault with the Honorable Single Judge's order only to this extent, my lord. Otherwise, my lord, it's a great judgment. We don't, my lord, we have no, my lord, differences, or we have no cries of any other nature, my lord. It's a great judgment. It's a great interpretation. Only thing is, my lord, our argument that we are considering them as personal guarantor is not attended to. Otherwise, my lord, the judgment holds good. It is very clear that as of today, we can't go to NCLT insofar as the partnership firms and individuals are concerned, because, my lord, that part of the law is not yet notified. To that extent, my lord, the learned single judge's judgment is absolutely correct. Yes.
What is 701 notification?
The notification, my lord, of the central government, where, my lord, by virtue of, my lord, section 1 subsection 3, by virtue of section 1 subsection 3, my lord, the central government could notify the act to come into force on the whole or part by part. Conditional legislation. Therefore, my lord, this part is now notified. Page number 701, my lord, is the notification where part of the IBC was notified in respect of personal guarantors. Otherwise, my lord, even the personal guarantors, my lord, could not have been proceeded against. Now, my lord, insofar as the partnership firms and the individuals, it is even still not notified. And the day it notifies, my lord, we may have to go before
So
the
it
court.
means that in relation to firm and partners, the provisions are not notified.
No, not yet notified. They have not yet come into force.
But
Inclined-
you are contending that you are falling under 95(1).
Yes. Because I am considering that firm as a personal guarantor, not as a partnership firm. That's the reason, my lord, we have pleaded the firm and all its individuals.
Which firm? Manyata.
Yes, Manyata Realty is a firm.
And they have the joint agreement
Yes.
with bank,
With, my lord, yes, that
with corporate guarantee.
with corporate debtor.
Manyata Limited.
Yes. Therefore, my lord, we are relying upon that particular provision section, my lord, where the IBC, my lord, imports Contract Act and the.
And you are saying that whether you are right or not, it should be examined by the resolution.
That's all, my lord. That's all. I could be even, my lord, thrown out of the NCLT tomorrow. My lord, it's a novel situation, my lord. In fact, we were also looking for some judgments, my lord, where such kind of a situation was there before or not. And this is a novel situation, my lord. That's the reason now, my lord, throwing us out, that even you can't even file. My lord, that takes away our right of filing, that's all. We may be wrong, my lord, in filing, so but taking away the right of filing, my lord, the right of litigation, my lord, should be protected. That's all our submission. So grateful.
Interesting arguments have come, lords. In fact, your lordship will recollect in my first submissions I have made. I was emphasizing on the point that the partnership firm has not yet been notified. That comes under part 3. The other submission which I would make is that there is a lack of jurisdiction. Now, in the earlier contentions, this was never addressed. So to that extent, in fact, not after lordship posed a specific question in the last hearing, my friends have come up with a statement. Yes, partnership firm is not notified.
Which partnership?
The debt of a partnership firm or proceedings against a partnership firm under the IBC code is not notified.
So that will fall under 95(2).
95(2).
There you agree?
Yes.
Yes. Then?
Now, therefore, my lord, after so much of things this has come, now the next issue, whether there was a lack of jurisdiction, is still not answered. Because even if partnership firm, the day when it is notified, jurisdiction is DRT. Section 78, part 3. That essential requirement is that part 2 goes before NCLT, part 3 goes before DRT. Now, a portion of part
2 go before NCLT.
NCLT, which is against companies. Part 3, my lord, goes before DRT.
Where is that?
Individuals, section 79, my lords. Part 3 itself starts from section 78. Itself, my lord, any provision, my lord, any enactment is on applicability coming into force. Therefore, my lord, any enactment will have a initial section. Now, please see 78. It says, this part shall apply to matters relating to fresh start, insolvency and bankruptcy of individuals and partnership firms where the amount of the default is not less than 1,000 rupees, provided the central government may, by notification, specify so and so, so and so. So applicability in terms of 78 gives a clear description. Individuals is one category, partnership firm is the other category. Now 79, in this part, unless the context otherwise requires, adjudicating authority means the debt recovery tribunal constituted under subsection 1 of section 3 of DRT Act, then so and so, so and so, so and so. So part 3, the jurisdiction is with DRT. When they admitted to the fact that the partnership firm is not yet notified, what they are trying to do is that, please see the petition itself, page 95. But I am not able to even comprehend how they get over this situation. Page 95. The first respondent shown in page 95. Page 95, my lord, the first respondent is a partnership firm. On the one hand, you contend partnership firm is not yet notified. The provisions of the code has not come into force insofar as partnership firm is concerned. But the petition is filed against a partnership firm. But this seems to be very, very strange. Now, answer from them comes saying that.
Now, who are the borrowers?
There is
Borrowing is upon joint agreement.
Yes, yes.
So why that company is not party here?
7 and 8. 7 and 8, my lord. As against the company, my lord, there is a section 7 petition which is already pending before, my lord, the NCLT.
Already pending,
Yes,
separate.
yes. And my lord, I am not, my lord, interrupting my learned friend. Only one provision, my lord. Section 60 of, my lord, the IBC may kindly be seen, my lord. I am sorry. Section
Lord,
60.
I'll take your
That
lordship.
I can put an end to this, my lord, confusion. Section 60 of the IBC, my lord. Section 60, the adjudicating authority. The adjudicating authority in relation to insolvency resolution and liquidation for corporate persons, including corporate debtors and personal guarantors thereof, shall be the National Company Law Tribunal having territorial jurisdiction. If I call somebody as a personal guarantor, may it be a partnership firm, may it be an individual, may it be a proprietary concern, may it be an LLP, I can't go to a DRT. DRT is only for partnership firms.
Yes.
That is the mischief, my lord.
Yes.
They now claim that I will call somebody a personal guarantor. So therefore, the question comes, does the code give a room for that? If there is a specific definition under the code, can you call a firm? Tomorrow you may say that I will call a company also as a personal guarantor. Now, what would be interesting is that this particular partnership firm has two companies as partners. Partners of the firm. Now, in page 95, what your lordship saw is that first respondent is a partnership firm. Now, what is the answer from my friends as to how I maintain a petition against a partnership firm before the NCLT? No answer. They only say, I treat them, I consider them. Contrary to the code, my lord, can they say that I will consider them?
No, they are advancing their capacity as individual guarantors to the corporate body.
Yes.
Firm, but it is a firm.
No, but that is firm is a joint as respondent.
Yes,
They are saying that we have locus
yes,
and a kind of entitlement flowing from 95-1.
Yes.
And that 95 is wider than 95-2. Not wider, it is irrespective of 95-2.
yes. 95(2) restricts to partnership firm. That is what not Supreme Court clarified. So 95(2) doesn't restrict one because one covers entire individuals.
95-2?
2 is only for the partnership debt.
Correct.
So there in that case of a partnership debt, there may be individuals who are partners. So that is the context Supreme Court said. 95(2) doesn't restrict 95(1) because it is a wider sense. Now, can they claim that I am considering, I am deeming, I am equating them?
That is the question.
That is the question.
And-
What not answer, your lordship?
And the next question is who will decide at what stage it will decide?
Not the answer, not even before going to that, the answer lies from their own reference as to the definition at 522, section 5, subsection 22. Section 5, subsection 2.
Personal guarantee.
Personal guarantor definition means an individual. Code deals with individuals and partnership firms by clear application in terms of section 78. And there is also one more provision which I'll show your lordships. So here,
Personal guarantor means
an individual.
who is surety in a contract of guarantee
Yes,
to a corporate debtor.
yes. Now, first thing, my lord, who is this individual? Can you assume when the code says it is an individual, can you assume a firm to be an individual?
They are partners.
Their partners will be an individual insofar as the firm's obligations are concerned.
No, they are asserting.
Insofar as the firm's obligations are concerned.
Probably, if we have understood rightly, they are probably asserting their individual capacity as partners.
I'll show all those things also. I'll show your lordship as to how they assume, how they say. Now, please see this provision alone.
Will not say as partners, they are asserting individual capacity.
Yes.
As corporate,
incorporated.
as corporate guarantor.
Yes.
Partnership Act is incorporated.
Next follows. Lord, I'll not for the moment go with your lordship things. Now, please see means an individual.
Now we have understood their argument.
Yes.
Now
Now, the same provision. Who is the surety in a contract of guarantee? He doesn't trust with an individual. It is in the context of a surety of contract guarantee.
they are not surety.
In a contract of guarantee, code specifies.
Is it not a contract of
guarantee. There is no contract of guarantee.
What is that page
685.
685.
Yes, yes, class 5. They together they are liable. And the Partnership Act is now lifted and incorporated. All individuals are equally liable.
That what is guarantee, my lord, we are saying section 126 of the Contract Act is also incorporated, my lord, in the IBC. It has to be read along. It's an explicit or an implied guarantee. It has to be read along.
Yes.
So definition of the code is very, very clear. Personal guarantor means an individual who is a surety in a contract of guarantee to a corporate debtor. Now I am saying there is no such plea on your part that there is a contract of guarantee. No document.
So then
And
what is-
that contract of guarantee is executed by an individual is also not the
so
case.
according to you, page 160, 685 document is what?
It's an agreement between two parties. Now let us see that document. My dear Lordship will, I'm grateful to your Lordship. Not your Lordship will now see that agreement. 685. This agreement executed on the 5th day of November 2012, 6th day of November 2012, between Manyata Infrastructure Development Private Limited, Manyata Realty.
Yes.
685. First one is a company, Manyata Infrastructure Development Private Limited. Then it says Manyata Realty, a partnership firm. So two entities called as owners, which expression wherever so and so, and Mantri Technology Constellation, who is the appellant, called as developer. Then not over the page, it speaks about transaction as between these two entities and the developer in the nature of memorandum of understanding, joint development agreements relating to a property development. Not that your Lordship can skip.
So there is no guarantee clause.
There is no guarantee clause. Now please come to 687, which they are trying to again and again hard. There is no loan also, my lord. A mere word saying repayment is being used by them to claim it is a loan agreement. Dehorse the fact it says about advance. Not an advance also has to be repaid. Now 687. Clause 1, under clause 5, clause 1, the parties here to agree that out of the amount of 183 crores and odd paid by the developer to the owners, I am reading 687, but next.
But then again, Mr. Counsel, the question boggles is that whether at what stage this should be gone into.
But at the very inception, if there is some mischief, if there is some abuse of process, Supreme Court repeatedly says, please bud it at the inception, nip the bud at the inception.
So it boils down. that
No, that is
they-
why.
They invoke 95 only to take advantage of moratorium. That is the ultimate sum and substance.
Sum and substance.
And that is abuse of process. also.
Yes,
And that on facts it is not maintained.
yes. Because on facts, I can understand if somebody shows that this is a deed of guarantee and I dispute, it is a different issue. No deed of guarantee. Somebody shows this is a loan agreement, there is a liability as a loan. There is no such loan agreement. Agreement which they refer relates to a property transaction between entities. Payment of advance by one entity to the other. Advance to be treated as interest-free or interest-bearing. Therefore, it uses a word repayment.
Now this monthly technology has become buoyant technology.
Buoyant, yes, Your Lordship. Therefore, not on facts, on their own contentions. Now, that is why I'm not, Your Lordship, I am troubling again and again, taking to that petition itself. So I have showed at the first instance, the first respondent is a partnership firm. But Your Lordship has a point saying that when I am suing a partners, I have to show the firm. Now here, the code defines as to who can be a personal guarantor. Code also specifies about debt arising from a partnership firm. Both are exclusive of each. There is nowhere inclusive provisions. Now, that being the case, now please see the petition also, my lord, page 100 onwards. Your lordship will only bear with me, my lord, though we have been taking a long time. It requires some kinds of consideration.
Taking long time, we are taking long.
No, my lord. We
Yeah,
have been
this
trying to trouble your lordship repeatedly again and again on the
I
same
must be
thing.
very clear before we proceed further.
Page 100, my lord.
Both of us.
Page 100. Because arguments came that I am considering it to be a personal guarantor. Firm is to be equated as a personal. These are the arguments. Now, please see the contentions in the petition. Page 100. Now, rightly it starts.
Page 685, it is the firm which is the party, not the person.
Not the individual. No individual is the. Firm is signed as a owner of a land. Obligations arising from a land transaction. Advances said to have been paid. Arrangement is made saying that this interest-free security deposit for some period will be treated as interest-bearing security deposit. So requirements of 522. Page 100, my lord. What is their contentions on document before the tribunal, which they cannot go back today. They start off saying that the present application has been filed by the financial creditor applicant herein against the personal guarantors of the corporate debtor. If this is the word, my lord, 522 will immediately come in. If you are claiming personal guarantors, definition of the code is very specific. An individual who is a signatory to a deed of guarantee to the liability of a corporate debtor. It is not there. Now then they proceed. Filed under 95. Now please see the important words, my lord, which starts at page 102, paragraph 4. Paragraph 4. Yes.
Yes.
That stated in essence, a number of agreements were entered into among the financial creditor applicant on the first part and corporate debtor as well as its affiliated concern, the corporate debtor, namely Manyata Realty, which is a partnership firm. Clear facts. Nobody can dispute this. On the other part, the details of which has been provided hereinafter. Now, the structure of the loan agreement. Now, this is where the mischief comes. That agreement doesn't specify it as a loan agreement. It uses simplest a word as an agreement. The structure of the loan agreement dated 6/11/2012 was such that Manyata Realty had undertaken to stood as corporate guarantor. But how can somebody put in these words when document doesn't say so, when code doesn't provide any such things? Manyata Realty had undertaken to stood as corporate guarantor, and the partners of the aforesaid firm, personal guarantors, respondents of the present application, had accordingly undertaken to serve as the guarantors in respect to the loan availed by the corporate debtor / principal borrower. Such ingenious manner in which a petition is filed and tried to vest a jurisdiction with an NCLT, dehors the documents which they themselves rely, dehors the provisions of the code, or will it not amount to a clear abuse of process? For the sake of getting a moratorium, I will file something and say that 96 says the moment it is filed, interim moratorium comes. Then they say, in this regard, the financial creditor with great respect intends to draw kind attention of this tribunal that although Manyata Realty would also qualify to be a corporate guarantor, My lord, imagination can go to any extent. I as a counsel may keep on saying that I assume this, I try to equate this, but support of law is required. Support of document at least is required. A single word as to a loan at least should have been finding place in the document. Single word that they will stand guarantee at least should have found place in the document. Nothing of that sort. Yet, since it is settled proposition of law that any partnership concern constituted under the provisions of Partnership Act by virtue of law is indispensable from its partners, and as such liability of the partners in any partnership firm is unlimited. Known factor, nobody is disputing these first principles. In a partnership firm for a partnership debt, liability of the partners is coextensive. On the other hand, can you say that the partnership firm is a party to an agreement? Therefore, under the provisions of code which specifically says who can be a personal guarantor, I will say your liability is coextensive with the firm. Therefore, I will treat you as a personal guarantor. Very, very ingenious manner of saying, Lord, how things should not be done. Then next paragraph, next page. Therefore, all the partners of Manyata Realty who have been arrayed as party respondent in the instant application would qualify to fall under the purview of personal guarantors. And since the partnership concerned, Manyata Realty is indispensable from the aforesaid partners, personal guarantors. Therefore, Manyata Realty, in addition to all partners who are personal guarantors, would also qualify to fall under personal guarantors. Your Lordship not rightly put me a question saying that if partners are being impleaded, it is necessary firm to be impleaded. But see what is the statement not which they have made. Partners are individuals, therefore I will qualify them as personal guarantors. Since they are personal guarantors, I will also treat the firm as personal guarantor. Now, there should be an end to stretching these kinds of imaginations. And all these things comes in a context that the code specifies if it is a partnership debt in part 3, it is the DRT, not yet notified. And my friend repeatedly relies upon the Supreme Court judgment in Javrika, which was on a context of constitutional validity of these provisions.
When liability of a partner, this is abstract question, whether right or wrong, I don't know. When the liability of a partner is, even it is relevant or not, I don't know. Right or wrong, not logical or I don't know. But just I'm asking, good passing in my mind. When a liability of a partner is unlimited, vis-a-vis the firm.
Yes.
Can it be said that the capacity of partner transcends beyond the firm?
It cannot. Your Lordship question is very, very pertinent. It gives a very good thought. Suppose a partner independently gets into some liability, can the firm be met?
Whether it become independent of the...
Section 34 of the Partnership Act, my lord, answers this. My lord,
Unlimited to the partnership debt, not the vis-a-vis. Unlimited liability of the partners cannot be imposed on a firm.
Here it is partnership debt?
No.
No?
No.
How?
Because there is no such debt, loan or anything. That agreement simplister refers to an arrangement between the parties with regard to a land transaction.
Friend did not read the next page, 688, loan agreement, my friend read the first page.
You will have to, at least for the satisfaction of the court, demonstrate that this is a loan agreement.
Next
That-
page.
That it contains essentials of guarantee.
A loan.
Next page, next page, my lord, next page.
Whether we go into it or not, different.
We are not saying that, my lord. In fact, my lords, may kindly see the information utility says, my lord, the very next page of the partnership deed, my lord. My lord, information utility documents, my lord, they have the presumptive value. Kindly, my lord, have section page 690, my lord, 690 for a moment. My lord, we are not saying about this debt. This is not an illusory debt. Kindly have, my lord, page number 690. My lord, now this is also compulsory, my lord, when we are filing a petition before the NCLT to show debt. My lord,
Because they are questioning the very
it's
basis.
very liability, my lord. We will deal with it. Kindly, my lord, see for a moment, my lord, page number 690.
690.
690.
Yes.
My lord, these are all the information independently gathered by, my lord, the central records, my lord, national information utility, and my lord, they are available, and we have to file this documents along with the application. My lord, me saying that there is a debt, etc., will not satisfy the tribunal. Kindly, my lord, have page number 690, and my lord, the other party details, name. My lord, the second column. Second, my lord, table, name, Manyata Realty, relationship, debtor. Then, if your lordships could kindly come down to, my lord, the third table, debt information, sanction amount, 40 crores, term loan. My lord,
Debt to which, debt to?
my lord, this,
Thank-
my lord, this is on page number 690, as your lordship sees.
No, debt due to which?
The debt due to, my lord, the debtor, my lord, is first page itself, my lord.
Bionic technology.
Bion technology, my lord. First table.
Yes.
First table is Bion technology. The third table,
Yes.
second table, my lord, is of the debtor. The third table, my lord, is of the liability.
So this is record of what?
This is, my lord, record of information utility, and my lord, the heading, my lord, National E-Governance Services. My lord, these details are not uploaded by me.
All according to my interpretational questions.
My lord, at the end of the day, my lord, my
But
only.
this statement is wrong. I have to intervene. Please,
Yes.
please, same 690, I'll just conclude. 690, if your lordship sees, this is submitted by them to an information utility. First, on the top itself, unique debt identifier, then submission, submitted by Bion Technology.
All. We'll continue. After recess, only. After recess. To address us.
Yes.
Not curtailing you, but
Grateful.
whether this Hivarka has any observations about the
Applicability.
nature of proceedings at the stage of 95.
I will clarify that. There are some more judgments, my lord, which has. my lord,
Namely
which-
that it is only administrative act
Yes.
or a ministerial act of accepting the application.
At any case, my lord, our only argument is this, my lord. A writ of prohibition, my lord, it's issued as against, my lord, individuals now. My lord, the writ of prohibition, my lord, we don't, my lord, deny the authority of the Honorable Writ Court to, my lord, issue a writ of prohibition at
Yes,
what
a
stage?
writ of prohibition.
Yes, my lord, virtually, my lord, the judgment of the learned single judge, my lord, is a writ of prohibition. Lord, it prohibits a jurisdiction to be exercised by a particular, my lord, forum. Now, my lord, at what stage a writ of prohibition could be issued? Now, my lord, now the NCLT has not even, my lord, started anything. We have just filed the papers. Now, my lord, the writ of prohibition now runs against, my lord, individuals.
But today we'll conclude and then request you to submit.
Any day, my lord, any day on which your lordship, my lord.
Not convenient day in the second half.
We are convenient, my lord.
So we'll take
So
about
grateful.
half an hour.
So grateful, my lord, so grateful.
Yes.
Number 12. Often thought about only 5 minutes, my lord, I think, not more than. Let's kindly have a lot, page number 676, notice, rule 7 notice, which we addressed. Now discuss the rule 7 notice before going to my lord in security. The page number 676, my lord, is the rule 7 notice. My lord, under the rule 7 notice, we, my lord, said it clearly that what is our conception and how we are going to the NCLT. Then, my lord, to which they reply, my lord, the reply is found at page number 695. One paragraph in the reply, my lord, is important. My lord, that is paragraph number 4, which will be on page number 695, 696. My lord, paragraph number 4 of, my lord, the reply notice. My lord, paragraph number 4, they replied, in view of this, on behalf of a client, we notify your client that should your client proceed to file any proceeding before any authority pursuant to this misconceived notice, our client would be constrained to institute suitable proceedings against your client, including wrongful prosecution, fraudulent initiation of proceedings under the code, and for defamation. But Lord, the fraudulent initiation under the code they are talking, my lord, in view of section 65 of the IBC. Section 65. 65, my lord. What if, my lord, I go with my own story? Say I have a right to come to NCLT and I, my lord, abuse the jurisdiction of NCLT. Fraudulent and malicious initiation of proceedings. If any person initiates the insolvency resolution process or liquidation proceedings fraudulently or with malicious intent for any purpose other than for resolution of insolvency or liquidation, as the case may be, the adjudicating authority may impose upon such person a penalty which shall not be less than 1 lakh rupees but may extend to 1 crore rupees. If any person initiates voluntary liquidation, etc., etc., the penalty is provided. Now, this was their reply, that if you still go, I will initiate proceedings against you under section 65. Now, my lord, the moment I issued this notice, my lord, may I just, my lord, I apologize, my lord, I should have produced it earlier, my lord, may I just pass on one judgment of the Honorable Supreme Court, my lord, which concerns with anti-suit injunctions. Lord, in Modi Act time, only one paragraph, my lord. My lord, the pagination is in the bottom. Kindly have, my lord, page number 8. Page number 8, my lord, paragraph number 9. The courts in India, like the courts in England, are courts of both law and equity. The principles governing grant of injunction and equitable relief by court will also govern the grant of anti-suit injunction, which is but a species of injunction. When a court restrains a party to a suit or proceedings before it from instituting or prosecuting a case in another court, including a foreign court, it is called anti-suit injunction. Now, my lords, may kindly have, my lord, the Honorable Supreme Court defines what is the anti-suit injunction. Now, my lords, may kindly have page number, my lord, 15, 1-5 in the bottom, my lord. Pagination is in the bottom, page number 15, paragraph 23. From the above discussion, the following principles emerge in exercising discretion. Page number 1-5, my lord, 15. Pagination, my lord, is in the bottom.
Yes. Paragraph?
Paragraph number 23, my lord, the conclusion. From the above discussion, the following principles emerge. In exercising discretion to grant anti-suit injunction, the court must be satisfied of the following aspects. A, the defendant against whom injunction is sought is amenable to the personal jurisdiction of the court. B, if the injunction is declined, the ends of justice will be defeated and the injustice will be perpetuated. And C, the principle of comity, respect of court, respect for the court in which the commencement of continuance of action proceeding is sought to be restrained must be borne in mind. Number 2, in case where more forums than one are available, the court in exercise of its discretion to grant anti-suit injunction will examine to which is the appropriate forum convenience, having regard to the convenience of the parties, and may grant anti-suit injunction in regard to the proceedings which are oppressive or vexatious or in a forum non-convenience. Now, my lord, the reason why, my lord, I am referring to this judgment is the moment I sent a notice clearly saying, I'm not even hinting, my lord, I'm clearly saying I'm going to go to the NCLT against you. This is Rule 7 notice. You replied back to me saying that if you do this, I am going to bring action against you under section 65, etc., etc. If you still were of the opinion that I am likely to go there, and I would go there, the remedy for you was to bring in an anti-suit injunction, a suit for anti-suit injunction before an appropriate court. You waited till the application before the NCLT was filed. Thereafter, you came before the writ court. Kindly now, my lord, see the prayers in the writ petition. To kindly find the prayers in the writ petition on page number 89. Page number 89. Issue a writ or order, a direction in the nature of declaration, or any other writ or order or direction declaring that the e-filing of a petition in filing number so-and-so by the second respondent purported to be under section 95 of the Insolvency and Bankruptcy Code as against the partnership firm and its partners as void ab initio, illegal, non-est in law and lacks jurisdiction, and the same as non-existent in the eyes of law. B, consequently, restricting the first respondent. My lord, the first respondent is NCLT, the registrar NCLT. Consequently, restricting the first respondent from taking any action in furtherance to the said petition filed by the second respondent in filing number so-and-so under section 95 of the Insolvency and Bankruptcy Code, including completing the scrutiny of the petition filed by the second respondent, returning the petition to the second respondent for rectification of the defect, and or numbering and registering the petition or placing the petition for hearing, etc., etc. These are the
Anti-injunction.
Now, my lord, the
Is what you are saying.
No, my lord, these are in the nature of a prayer for an anti-suit injunction. Now, my lord, now the question is, can a writ court grant these prayers? My lord, by issuing a prohibition. Now, my lord, to issue a prohibition, a wrongful judicial authority or a wrongful judicial forum should have exercised a jurisdiction which is not vested in it. Or it should not have assumed a jurisdiction without the basis. Then, my lord, a writ of prohibition comes where we come under 226 and say a particular judicial forum not vested with the jurisdiction is entertaining, therefore prohibit. Now, my lord, here is a case, such a jurisdiction is yet to be exercised.
First prayer is justified, second prayer is justified.
Both are not justified.
That is your submission.
Both are not justified.
No, in the context of nature of anti-injunction.
Anti-injunction.
If first prayer is justified,
yes,
then second becomes the writ of prohibition.
Writ of prohibition.
If first is right,
yes,
then second is right.
And, my lord, our Honorable High Court being not, my lord, a judicature court, my lord, the original jurisdiction to issue reliefs under the specific relief act, which is in the nature of an injunction or anti-suit, my lord, does not vest in the Honorable High Court. And 226, my lord, cannot be used as a parallel to the jurisdiction, my lord, under section 9 of the CPC. Therefore, my lord, my humble submission is that they had the remedy elsewhere. And all my learned friends' argument, my lord, for a moment, my lord, we accept. Yes, According to my learned friend, the loan agreement, there is nothing called loan agreement. We interpreted it and we used it, we termed it wrongly as no longer loan agreement. There is no guarantee. We interpreted it and we tried to bring something in the brackets of guarantee. All these things will have to be gone into by the resolution professional at the first instance. He generates a report. My lord, if the RP says, no, this entire petition is a sheer abuse of process of law,
then it will go to NCLT.
it will go before the adjudicating authority, my lord. Adjudicating authority,
No, if RP says that this is not maintainable, then
my lord, it will be a recommendatory report, my lord. RP
the
cannot-
report,
Yes, it's only a report.
then it will go to NCLT.
It will go before, my lord, the adjudicating authority, which is the NCLT. And my lord, the NCLT decides, the adjudicating authority finds all the arguments of my learned friend that we are trying to misinterpret, misquote, we are trying to do this only in order to extract the benefit of the moratorium, etc., etc. All these things, my lord, if kept before the NCLT, the Honorable NCLT feels it correct that yes, we have resorted to an abuse of process of law.
So that is-
65 will be rightly issued against us. In any case, my lord, my submission or closing statement is that in any case, my lord, a writ court's jurisdiction could not have been invoked to stop something from even being initiated. Now, my lord, if that happens, the entire judgment of, my lord, the Honorable Supreme Court in Jivrajka, my lord, this judgment, my lord, would greatly disturb the judgment because one more, my lord, judicial stage or a judicial tire would be created before, my lord, RP, which is not conceived by the lawmakers under the IBC. 226, my lord, is a rarely used jurisdiction to, my lords, to stop a legal proceedings, which should not have been done, my lord, is my humble submission. So grateful, my lord.
But I assume that my friends have finished it because every now and then there is something which is new coming up, so that I will also complete my submissions. But as regarding this last contention, the 226 should not be invoked and only a civil remedy should be invoked, not is very, very strange contention. You cannot restrict the power of 226, not equating it to saying that you have a remedy of anti-suit injunction, therefore you should have gone that. But courts have repeatedly held as to prohibition is against the proceedings. And my friend read the Supreme Court judgment saying that the very filing under 95 initiates everything. That is what the learned single judge also said. That if it had been a case that post-filing there is something which has to be done in terms of an adjudication by the tribunal, it is a different scenario. But code is put in such a way that the moment you file, something kicks in immediately. Therefore, there is a consequences which flows. That is the context not in which the proceedings is being sought to be attacked. Now, dehorse that. But ultimately, if your lordship is accepting my contention that the NCLT has no jurisdiction, it is not a case of blood jurisdiction being vested and there is an error of exercise of jurisdiction. But this is a case of absolute lack of jurisdiction. The so-called resolution professional or adjudicating authority, all those things doesn't arise because if your lordship accepts my contention as regarding these claims are only related to a partnership, there is no personal guarantee, it is absolutely outside the purview of the NCLT. But I'll, just for convenience, I'll put it across, but I need to take a lordship through some documents, some relevant pages alone, because even petition, I did not complete, but I'll do that, then refer to some provisions and the judgments. This will be my concluding. But your lordship was lastly seeing this page 690, which my friends were harping upon, saying that there is an information utility record. Now, please have a look at page 690, my lord, for a moment.
Six
690, my lord. Now, this is stated to be record of financial information, Form C. But this is covered under the information utility regulations. It says IBBI Information Utility Regulations. Form C is the initiation stage. Somebody goes and files a Form C saying that somebody is in default of something to me. Now, post that, in terms of regulations, what happens is that there is something called Form D. Record of default has to be generated. That is the generation from the information utility, before which there are certain processes to be done. But what is being referred here is Form C. Now, from the wordings of Form C, your Lordship will find third line, it says submitted by this appellant. So it is your information which you are submitting. Now, then second tabulation, name, Manyata reality, relationship, debtor. Not a claim of guarantor, which they have been harping now. According to them, even in terms of the Form C, my lord, the partnership firm is a debtor. Then your Lordship will find next tabulation on the debt information, type of debt, financial, debt start date, 6/9/2017. They rely upon an agreement dated 6/11/2012. So what is this information which they have given, my lord? We do not know. What were supporting documents to Form C? We do not know. From Form C, what emanates is that they say debt start date is 6/9/2017. Then sanctioned currency is INC, funded type is funded. Same line on the right hand side, last corner, it says unsecured. Then sanctioned amount, on the right hand side, it says term loan. Then date of default is again 6/9/2017. Every detail in terms of what they provide as to the Form C filed before the information utility by the appellant themselves is contrary to whatever they have been arguing. What was the term loan? Nobody says. In the entirety of the pleadings, there is no such reference of any term loan having been given as 40 crores. And they themselves claim that it is only the debtor, not the guarantor. Now, my friend referred to the notice which is at page 676. In fact, my friend refers to, not if your Lordship sees the Form C filing in terms of the regulations, under that clause 13, it in fact gives the details: debtor, creditor, guarantor, co-obligant. Just for convenience, I'll just ask them to show this now. This is the regulations which provides this Form C and D. Point number 13. Left-hand side, sir. Point number 13. Left-hand side. So form gives those entire classification also. So in the same classification, they could have said guarantor. But what they have said is debtor. Co-obligant is also given. So it can be a guarantor, creditor, debtor, co-obligant. So these are the regulations which are guiding insofar as this record of default, which emanates from information utility.
It is supposed to be part of section 95.
Yes, ma'am. In any case, section 7, 9, part 2, part 3, for everything, this is common. This is common, not information utility. Now, please come back to 676, ma'am. The so-called demand notice under Rule 7, which my friend just now referred to your Lordship also, 676. Form B, Rule 7, demand notice, not after reference and date, 21/10/2023. Please note not how they have addressed to debtor. So according to them, even in terms of this notice, they claim that there is a partnership firm which is a debtor. Then just below that, your Lordship will find they write as personal guarantors. The partners are sought to be termed as personal guarantors. Now, I would like to take your Lordship back to that NCLT filing which had been done, which I was referring earlier at page 100. Page 100, I refer to page 102, paragraph 4. This is the sum and substance of the application. Number of agreements were entered into among the financial creditors, so and so, as well as affiliated concern. Manyata Realty, which is a partnership firm, on the other part. The details of which has been provided in after the substance, the substructure of the loan agreement dated 6/12 as such was such that the Manyata Realty had undertaken to stood as a corporate guarantor and the partners of the aforesaid firm, personal guarantors of the present application, had accordingly undertaken to serve as the guarantors in respect of the loan availed by the corporate debtor, principal borrower. There is no loan agreement. Even that agreement doesn't speak about any availing of loan. So-called advance in a land transaction is sought to be treated as interest-bearing advance for a particular period. Therefore, it has to be repaid. This is the agreement. But they say, my lord, as if a loan availed. In this regard, the financial creditor, with great respect, intends to draw kind attention of this tribunal that although Manyata Realty would also qualify to be the corporate guarantor, yet since it is settled proposition, but this I read to your lordship, but I don't want to trouble your lordship, over the page, third line onwards, would qualify to fall under the purview of personal guarantor, and since the partnership concerned Manyata Realty, so what provision which is there in the code is sought to be, my lord, put in a different manner. Now the petition goes on, my lord, I am not troubling your lordship taking through, only relevant, please come to page 113, 113. Same petition. Paragraph 13. It is pertinent to accentuate herein that the structure of the financial transaction arising out of the contractual framework was restructured in such a manner that the corporate debtor would be deemed to be the principal borrower and the affiliated entity, Mrs. Manyata Realty, along with its partners, would be deemed to be personal guarantors and the corporate guarantor, as the case may be. Since the guarantor, namely Manyata Realty, is a registered partnership firm, thus the partners of the said firm are jointly and severally liable for the acts of the firm, thereby would also be deemed to be personal guarantor. They are not in a different way trying to bring in as if there is a deemed guarantee. Partners are deemed to be personal guarantors, and not in top of all these things say that the partnership firm is also a personal guarantor. They go on writing, Lord, I'm again not troubling your lordship referring to all those things. Now please see, Lord, page 118, Form C, where again your lordship will find the same manner in which they went ahead, reflecting everybody. Page 121. This is the format in terms of the rules. Page 121, part 2, particulars of the personal guarantors. One is the firm. But in spite of all these things, I still fail to understand how you can term a partnership firm as a personal guarantor. Given the specific definition under the code which specifies that an individual who is a signatory to a deed of guarantee. Then they go on giving details of all the individuals. Then please come to page 232. 232, Form 13, same wordings which has been repeated from the earlier paragraphs. Page 232, paragraph 13 within the tabulation portion. I'm not repeating that, the same wordings, whatever they have said in a paragraphs, they have again imported into the then page 256. This is the filing which they claimed. Page 256, the e-filing receipt, which effectively is a payment receipt for having e-filed it. Your lordship will take note of the date, 22/11/2023.
So the prayer in the writ petition was to set aside this,
Set aside the filing, yes.
this one.
Yes. Proof of filing is this. Now, my lord, there was enough argument saying that this interim moratorium is only for 14 days or 40 days or 44 days. Nothing happens, so forth, so on. What my friends have not informed your lordship is that all those triggering happens once it comes before the adjudicating authority. The days of 14 days or 44 days, everything will come once it comes before the adjudicating authority and IRP takes its role. Now, in between what happens, nobody knows. Now, in fact, as far as this case is concerned, this filing is 22/11/2023. Not immediately on 23/11, they filed a memo before the arbitral tribunal claiming interim moratorium. 22/11 it is filed, in fact 14-15 hours. Then 23/11 claim before the arbitral tribunal that there is an interim moratorium. Now, writ petition was filed on 1/12/2023. Interim order on the writ petition was on 7/12/2023. But as between this period itself, more than 15 days have passed. As between this period itself, not more than 15 days have passed. No action was there. So all these claims of 14 days or 44 days not comes in a different context in terms of the regulations when the IRP steps in. Now, my lord, please come to page 257, my lord. This is the partnership deed. I'm just referring for the point. At 257, your lordship will find the first party to the partnership deed is a separate company who is signatory to the partnership deed. Now, there is no claim as against this company. If your logic has to be drawn to a conclusion that the partners are personal guarantors because of joint and several liability, firm is also a personal guarantor because the partners are guarantors, then what happens to the company? There is absolutely no answer. So that logical argument has to now go into a position saying that even if it is a company, it is a personal guarantor, which will make a mockery of whatever is the provision.
Last argument I didn't get.
That logic saying that partners of a firm has to be treated as personal guarantors because there is a joint and several liability. If one of the partner is a company, that company will also be a personal guarantor in terms of their argument.
So what turns upon that?
Contrary to what is the provision in the code. That we will be making a mockery of the system. If the code intended that all partners of a firm will also be qualified as a personal guarantor, but legislature is conscious of these facts. In a partnership firm, there can be any number of partners, different categories. Now, page 259, seventh party, point number 7, is again a company. Not just drawing to the fact that how an abuse is being not placed on before the court as to for a simple means of defeating an arbitration proceedings. But this is not an isolated incident also. As I pointed out earlier, it is not that by only this means they did it. There were earlier, as I pointed out, 7 writ petitions, 14 interim applications in the arbitral tribunal, invoking various provisions of the CPC. But then your lordship will please come to page 316, my lord. This is the first memorandum of understanding as between the parties, where your lordship will find, my lord, at page 317, the parties go on to show, my lord, there are various individuals, partnership firm, company, everything. At 319, my lord, they entered into with the appellant. Where is the claim form? Claim and counterclaim. But can I take a lordship to volume 2, my lords? Just few more documents, my lord. My lord, the claim before the arbitral tribunal, my lord, starts at page 377. Then, my lord, there is a counterclaim filed. But I'm only pointing out, I will not trouble your lordship reading through. That was the first statement as to the party before a judicial forum, be it a quasi-judicial arbitral tribunal. There is no such statement that there, for a loan of 40 crores, that there is a guarantee by the firm. Now, before the arbitral tribunal, individuals are not parties. That is the reason why I wanted to point out this 377 filing of claim. Company, partnership firm are the only parties. Page 377, your lordship will find, as against the respondent. The means by which they devise
Is their argument, namely that what we are arguing is not relevant at 95.
I am pointing out to the fact, my lord, how the abuse is being
One line argument.
engineered by them.
That what you are arguing with such elaboration is not to be argued or considered at section 95 stage.
No, my lord, it comes in the context because section 95 is filed showing the first party a partnership firm. Their contentions, if the partners are personal guarantors, is considered, still they will not achieve the objective. Because these individuals are not parties before the arbitral claim. To achieve that objective, they bring in the firm also, qualifying as it also becomes a personal guarantor.
Understand what is expressly not maintainable is made maintainable by clever drafting.
Yes.
The
I am grateful. I am grateful.
Arguments.
I am grateful, madam. I need not take your lordship any further more on this.
We want to see that with judgment. Jivraj ka.
Yes.
So whether the nature of, what is the nature of consideration at the stage of 95? Anywhere it is discussed?
Yes.
In this
No, my lord, it is not there, but I'll take a lordship through that judgment. In fact, relevant judgment is Lalit Kumar Jain.
Let us see.
Lalit Kumar Jain. But before that, can I only finish referring to certain provisions, my lord? Because this is important. Now, your lordship will not get back to the provisions, my lord. Very interesting what your lordship will note is that, my lord, I started off saying that coming into force of an enactment is a particular process. Every statute says that not on and date when it is notified, the act will come into force. This act is concerned, not it is section 2. What is interesting, your lordship will find in section 2. Section 2 of IBC. Application of the act is specified. Section 1, Lord, speaks about section 1(3) speaks about it shall come into force on such date as the central government may by notification in the official gazette appoint. This is section 1(3). Now, section 2, the provisions of this code shall apply to any company incorporated in the Companies Act or under any previous company law. Any other company governed by any special act for the time being in force except insofar as said provisions are inconsistent with the provisions of special act. Any limited liability partnership incorporated under the Limited Liability Partnership Act. Such other body incorporated any other law for the time being in force as the central government may by notification specify in this behalf. Then D. D is important. Now, D, earlier it showed personal guarantors to corporate debtor. Now, earlier this E, after D, E, Lord, came into force by Amended Act 8 of 2018. They amended the enactment in the provision relating to application of the code by specifically bringing in a class of persons claimed as personal guarantors to corporate debtors. Then F speaks partnership firms and proprietorship firms. So before coming into force of this E, it read as individuals and partnership firms. So what was individuals and partnership firms was amended in the application provision of the statute by bringing in specifically by clause E, personal guarantors to corporate debtors. Now, this classification was the subject matter of challenge before the Honorable Supreme Court in Lalit Kumar Jain. Now, that I'll show your lordship. So this is one aspect. But by this itself, your lordship will find the legislature intended to ensure that this is a separate class, nothing to do with the partnership firms. Then section 3, my lord, speaks about, is on definitions. Now in section 3, subsection 23 is an interesting definition. It defines a person.
So person is distinguished from the personal guarantee.
Yes.
Here there is no person, understood.
Yes. No, but this is unique because it is unique to this code. I am only pointing out for the factor. If a code has a particular manner, you cannot.
In the definition of person, the personal guarantor is not.
Yes.
Understood. That is.
Not only that, it also speaks about an individual. It includes an individual, HUF, company, trust, partnership, a limited liability partnership, any other entity established under statute.
Nothing turns upon it because personal guarantor is different, separately defined.
Yes, class lot which they wanted to bring in.
There you are right.
Part 2, if it is a corporate, wherever I use a word person, it has to be seen in the context whether it is part 2 or part 3. Wherever it uses a word person, it may be in the context, may be an individual, may be a partnership firm. So that is the context in which a definition is given for that. When that is the case, when specific definition is there, you cannot assume or you cannot say that it is deemed, all those things will not come into. Now, one more argument was placed, but same section 337. My friend argued by means of section 37, the provisions of other enactments are read into. This is the argument. But what is relevant to point is that section 3 is on definitions and subsection 37 of C, the 3 is words and expressions used but not defined in this code, but defined in the other statutes. So whatever definitions for specific words which are defined in this code will have that meaning. If there is no such definition and if specific words are relevant, it will have the meaning in terms of other statutes. So it is only for the purpose of definitions. By this, my lord, they cannot say that there is reading into provisions of other statutes in whole as it is. And for us, my lord, as far as this case is concerned, suffice to say that personal guarantor is defined.
They are saying that contract of guarantee is not defined here.
Yes.
Therefore, it has to be to refer to partnership.
Yes.
And understood what is.
No, definition of guarantee in terms of contract act, not partnership.
Here it is not defined.
Here it is not defined.
Therefore, you can refer to partnership.
Here it is defined who is a guarantor, who is a personal guarantor.
It is how 237 is referred to. 337.
Yes.
437.
337. 126 contract act, right? It can be either oral or written. The guarantee itself is not defined.
Words and expressions.
Expression, words which are not defined specifically here. And if there is a definition under the statutes, those statutes will be. And I don't think partnership anywhere says that there is a guarantee. Partnership Act would say that partner's liability is coextensive of that of the firm.
The word defined.
That is for the purpose of the partnership debt.
The word defined in 37 is not limited to the section of definition.
Yes.
Any concept which is defined.
Yes.
But not defined in this act.
I only pointed out it is shown in a definition provision. But there are instances.
Difficult to explain.
There are the instances, your lordship will recollect, as far as DRT Act is concerned, Surface Act is concerned, specific provision was given that the other laws will also be applicable. Like SEBI laws or other things will be applicable. That is a specific provision. Here it is part of definitions. I am only reading to the extent saying that this subsection of 37 referring to other statutes is made part of the definition provision of the enactment. Then, my lord, 522, which your lordship had seen it so many times, effectively, my lord, I am only reiterating, it gives the definition of a personal guarantor means an individual who is a surety in a contract of guarantee. Having said so, my lord, it is my respectful submission. You cannot fall back to Contract Act and say that there can be an oral guarantee, therefore liability. Code provides not rule-making power, regulation-making power, which is vested with IBEBI. Regulations have come. You are bound by within the framework of the law as regarding even a filing. But today, I cannot go before an NCLT or DRT and file something like what I file as a plaint. I am required to satisfy the requirements which are set out in the forms.
And how much further time will be able to take both?
Another 30 minutes, my lord, if your lordship pleases.
No, only thing that if it is more than 15 minutes, then some other day, because other matters should not suffer.
I understand, I appreciate, but I need to complete it, not because enough has been
So
said.
your judgment in Lalit and the judgment in this,
Jivraj. In fact, Jivraj ka considers Lalit.
so that much part will remain.
Yes, Jivraj ka, my lord, takes into account Lalit.
The lordship can consider on Tuesday, my lord, subject to your lordship's.
18th,
Can it be 19th, not 18th? I have some difficulty at Madras.
19th,
19th.
19th. 19th at 2:30,
Yes, my lord, I'm good.
not beyond half an hour.
Yes, my lord, I'll complete it. I'll do it.
Yeah. Keep this book for me because I have question. Is that judgment, Lalit? It is,
No, I'll circulate it.
it is referred to in,
We have not filed it, my lord, we'll.
No, I've got the copies, my lord, I'll hand it.
in this it is referred.
Because it was squarely on a point of challenge to the notification.
Very
Yeah,
good.
really.
Give the citation.
I'm giving the
Jivraj ka, my
copy,
lord,
ma'am.
considers Lalit.
Lalit in country.
Jivraj ka considers Lalit. Lalit is considered in Jivraj. My lord, now it's being followed, it's followed across. It's a lot reported law as of now.
It is followed there now.
That a registration can be challenged, that a registration can be challenged. My lord, this is the first judgment, my lord, in the country.
Provision is such that, my lord, that is the difficulty. 96 immediately steps in. Oblige.
Okay.
List number 2, seal number 5, to Vinay Kutappa.
Need MCC as a response number 4. I think I'm first time. It's just Shanti Bhushan is appear for the same. Yeah. My lords, I amended, I amend the petition, my lords. Maybe taken up tomorrow, my lords, which one? My lords?
My lords, the portal will be open and counseling start, and I'll lose the opportunity, my lord, so I have.
Not
to
ours, my lord. In our
Then-
portal, my lord, his application is perfect. There's no problem. Only there, my lord, another 3 weeks, my lord, I think, third week of July, they may start. Subject to what Supreme Court says.
It will be delayed immediately if the counseling is begun, so that's a urgency, my lord. Second,
He's here. My lordship, kindly take note the application form. As far as state is concerned, my lord, we consider this application as it is, but perfect, it is perfect. This category will be considered. He wants to change in the application made to NTA. Lordship, follow that. This could be done.
Lord, the ranking changes, my lord. The ranking in the general list will change if it is all India quota. Lord, his prayer is only for insofar as the Karnataka, if your lordship may kindly turn to page 11, my lord.
We will accept this application is there.
Lord, we'll follow it, my lord. There. Lord, he is applied. Please. Lord, KEA, if it is for the state quota, my lord, it is for the KEA to decide, my lord, whether it's to be given or not. Now, my learned friend is asking for the state quota, my lord, it may be allowed, my lord. I have no objection. Please.
Let's go with the, he does not have to be any apprehension on that.
Insofar as it is the state quota, my lord, now. Submissions, state quotas, only state quota. Great.
Yes,
Lord. Lord, is.
on
Lord,
instructions I'm making.
my learned friend's petitioner statement also may be recorded, my lord, that it is only for the state quota, my lord.
the late judgment, is not followed, my lord, that may be permitted to amend the. To amend.
Please state quota,
He
my lord.
wants to live in state quota.
Please,
But
my lord.
he is not stated so in the prayer.
Only to amend the category. My lord. Application, my lord. Where in neat application she mentions.
Neat application is page 44, my lord, page 4. My lord, that's a misconception here. My lord, as far as central quota is concerned, he cannot be considered as 3A because 3A concept itself is not there. 3A concept is not there in the central quota, on SC, ST and category 1, only 3 quota. There is no other quota. These are all state quota.
State quota.
3A is a state quota. State quota. Okaliga community. Backward.
That's state quota.
Quota.
Annex to notification.
OBC only 3, SC, ST and category 1.
Annex to
Category 1.
Annex the notification.
Category 1 and
Category
L1.
OBC. That is, yes, that's
My lords, notification I have annexed in page number 33, my lords. Please, my lords, where it says in state of Karnataka, this, my lords, if we permitted, then chances will increase, my lords. If it's permitted to amend the application, need application, my. Your quota will not change. My lords, if, state quota is considered. Will change, not the. My lords, my. My lords, state if my quota is considered, I'll stick to the.
Great.
Yes, state quota.
Not necessary, madam, not necessary.
Actually, I did tell my relevant, it is not necessary.
Actually, I made what we tell as a party, my lords.
Great.
Cell number 78, Mr. Krishnan CV.
Yes, my lord, 15th is the examination that is being, yes, my lord. Senior is held up in Port Hall 10. This is, challenge against the single land single judges order. In similar matters.
In terms of state quota.
Today in the morning also, some report has passed an order permitting the.
1,859,23. 80. 23. State quota. Which?
What is the controversy?
9-6, my lord.
What is the controversy? What is the controversy?
But, that they have been admitted as the mop-up round was not also taken up.
Admitted to which course? Admitted to which course?
BAMS course, my lord.
BAMS.
BAMS, Ayurvedic medical.
Then? How many students are there?
9 are there, my lord.
9. 9 petitioners.
9.
Then?
As against 10.
Then? What happened?
There is an endorsement issued by the university, that is first respondent at annexure. Okay. Here to the writ petition, my lord. Asking the college to discharge them.
Why?
As they are not routed through the second respondent.
As they are not allotted.
Routed through second respondent.
Not?
Routed to second respondent. Second
That is
respondent
KE. KE. Then why they are not routed?
May I submit the?
Get the notification. Counseling itself was over by the time, Lord, they gave us this affiliation.
No, they are not supposed to be routed through KEA.
Please, Lord.
KEA is not the agency here.
KEA is the agency. Counseling has to be done. KEA is not, is there for counseling. Counseling itself was over.
But then how college can straightway admit?
Lord, can I pursue your Lord's get Lord one judgment under almost similar set of circumstances where Lord this honorable court had directed? Paragraph 7, Lord. What had happened was here also, Lord. Please come to Lord. Paragraph 2.
So counseling was over. Why it was over?
Lord, counseling was over on Lord 5th of December, 7th of December.
But then you can't be admitted after counseling is over.
Lord, what
How
happened?
can you admit it?
Lord, NEET, Lord, I'm qualified in the NEET exam.
You must abide by the timetable.
Lord,
You must be late in applying.
happened is, I'll tell you, Lord, what happened. Affiliation by the Rajiv Gandhi University, affiliation by, Lord, the National Medical Council, came, Lord, in December. By then, Lord, they had to carry out, Lord,
By the time counseling was over.
no, they had to carry out, Lord, mop-up round, stray vacancy, nothing they did.
Who?
KEA did not do it. Please look at, Lord, the counseling, Lord, the schedule that we have given. They did not carry out the mop-up round or the, Lord, the stray vacancy. This is all difficult. Under almost identical set of circumstances, please look at Lord, this order that was in WP 16/296. There are other orders also, Lord, which have been passed. Please come to Lord, paragraph 2, last line, Lord, or last sentence. Petitioner was sought for an appropriate to declare 39 students admitted to the unfulfilled vacant seats at the institution level on 4/3. After all the rounds of counseling by the Karnataka Examination Authority to be proper and legal. After all that, then, my Lord, this honorable court held, yes, you are entitled to be to admit, subject to, my Lord, subject to your lordship's further orders. These are all students who have paid the fees. In fact, my Lord, if your lordship's take, my Lord, university takes the fees.
Then
University,
many would be left out, meritorious, if this course.
no, my Lord, we are all meritorious. That's why, my Lord, we are.
No, there might be other merit higher than you in merit. We do not know.
But what happens is, after the counseling is over, my Lord, if the people can be admitted, it is not that, my Lord, counseling is, my Lord, absolutely essential. In fact, in this judgment.
How can you say?
Yes, my Lord. That's, my Lord, the, please have a look at, my Lord.
It may not be essential in that sense, but you can't by bypassing the counseling,
My Lord,
overreach the higher merit. You are trying to surpass the higher merit.
Lord, can I
Indirectly, even if you're not intending that, it will mean that.
Can I put it in this manner, my Lord, subject to my being corrected by my Lord? They should have held, my Lord, the third round. They do not hold it. They should have held the mop-up round. They do not hold it. Where do I go? My Lord, I am all students. My Lord, we have admitted. University, my Lord, NEET examination, we have passed. We have, my Lord, ranking, which is higher than, my Lord, last admitted people. And, my Lord, para 7 of this judgment, this honorable court specifically held, my Lord, in fact, there are other judgments also, similar situations.
So here, by the time the affiliation is granted, everything will.
That's my problem. Not only affiliation, even Rajiv Gandhi University, NMC, everything. That's my problem. And these are all students, my Lord, who have been admitted. And, my Lord, we sent that to the university. University accepts it, accepts the fees. After 1 year, my Lord, they say now we are discharging them. They have pursued the study. They have been, my lord, for 1 year they have studied. 2022, they got admitted. 2023, they say, now we are discharging. That, my lord, is absolutely unfair. Ara 30, my lord, my lords get that. Their lordships, my lord, have that.
Here,
13, my lord. Correct. In the light of submission without.
so
entry.
they, here court relied on some other previous.
Yes, ma'am. There are a couple of them. Got, my lord, one. From, my lord, we are all students. Ultimately, we have, my lord, we have studied for 1 year. At the end of the year, my lord, the university says I discharge.
So what university says?
Please come to, my lord, the last document. Please come to, my lord, page 94. 2022, we got admitted. We have been pursuing our studies. We have, my lord, the 1 year we have been pursuing.
You are in second year.
We'll now go to the second year.
Go to the second.
With reference about is page 94. Names of the following candidates admitted to Sri College are found not in the allotment list received. Allotment list not got close, but in the second row, third row was not done KEA. Both, my lord, mop up round is, that's also they did not do it. Otherwise, my lord, we would have gone through that and we would have, under almost identical set of circumstances, my lord, at least about 4 orders of this honor. And in fact, this judgment on the ground of parity, my lord, this honorable court has granted.
Case of collusion between the college and the student.
Absolutely not, my lord. We are students, my lord. We have never done that in our life. That I must tell you, lordship, frankly. In fact, I did, my lord, interview the students. It's not that he did not.
The supreme body is National Commission for Indian System of Medicine. Supreme body,
Yes, my lord. National Medical Council. It is also, my lord, granted as a-
National Commission
Yes,
for Indian System of Medicine.
we have not been admitted.
That is party here.
Yes. No, they are not. Examination authority, because they have not said that, my lord, NMC, my lord, is in the way.
No, which is the regulatory body, regulatory?
Rajiv Gandhi University. Rajiv Gandhi University.
No, Rajiv Gandhi University.
Yes, my lord. Ultimately, my lord, that is what it is. And please, can I request you to look at it from another angle? 1 year we have studied, 10 students. My lord, if they are discharged, Second year also, there'll be vacancy. First year also vacancy. Nothing, my lord. Who benefits, my lord? Please look at it from that angle also. I have studied for 1 year, my lord. All these 10 students who are before your lordships have studied for 1 year. They are, my lord, if they are not permitted to take examination, they have to be discharged. 10, my lord, seats go waste. 10 seats, my lord, in the second year go waste. 10 seats in the third year go waste. It's a national waste. We have studied, and my lord, NEET ranking, my lord, I have placed before your lordships. All of us have, my lord, have gone through the NEET because NEET is a mandate requirement, my lord, for admission. Page, my lord, 80 onwards. 81 onwards, my lord. NEET ranking also we have placed before my lords. Sorry, my lord, NEET ranking is at page 51, my lord. Sorry, my apologies. 51 onwards. 50 and 51 onwards. National eligibility come entrance test. My lord, that's a mandate requirement, my lord, that one has to pass. Today's first, sorry. Today's first matter also, my lord, was similar, I believe. I don't know, my lord. I was not here. That's my instructions. I don't know, my lord. I stand corrected by my lords.
They were without counseling.
Please, my lord.
First matter also, they were without counseling.
Are you sure? That's what he says, my lord. I stand corrected by my lords, my lord, but he says it is without counseling. In fact,
Which is this?
The Naik had appeared.
Which is the,
He also told me that, my lord, is similar.
which is the 3839? Which is referred to by learned single judge.
Copy. That is, my lord, 2122, I believe. Copy.
When the exam starts?
Not 15th of this.
15th.
My risk, my lord, at my risk, your lord shall permit me to take up the examination. Subject to, my lord, your lord is hearing me.
Our learned senior counsel, Mr. What's it? Withdrawal. Attested by learned advocate, Mr. For the petitioners. Petitioners are, how many petitioners? 9. Petitioners 9 in numbers. Whom are those who came to be ordered to be discharged. From the course of BAMS, academic year 22-23, by virtue of communication cum order, communication cum directive, dated 23/5/23 of the respondent Rajiv Gandhi, University of Health and Sciences, Karnataka. The discharge was directed on the ground that the names of those students, names of the petition students did not figure in the list of allotted candidates. Paragraph. It was this directive which was called in question by the petitioner in the writ petition. Learn a single judge relied on regulation 5/7 of the regulations of National Commission for Indian System of Medicine dated 16/22. Also, the regulation 5/7 Roman small 3, which empowers the university to approve the admission, to come to conclusion that since the admissions were in breach of those provisions, no relief could be granted. Paragraph. Assailing the order of learn a single judge and the view taken by him, it was submitted on behalf of the appellant's petitioners that at the juncture when the petitioners were to be allotted to the course, the college was undergoing the process of affiliation. The affiliation was delayed. In the interregnum, the petitioners had applied for admission to the college. Full stop. It was submitted that since affiliation was delayed, the rounds of counseling were concluded. It was next submitted that the petitioners could have been subjected to mop-up round after their admission. Third round or mop-up round.
And the mop-up.
To give them the admission.
More rounds. That was-
However, the third round or mop-up round was never conducted for the reasons best known to the respondent Karnataka examination authority. Full stop. In addition to the above aspects, it was given out that the petitioners have undergone the studies for full year and that they have prepared for the ensuing examination, which is to take place, which is to commence from 15th of July. It was harped that the discharge of the students would cost them their valuable time in career. Learned Senior Council relied on decision of this court in Achyuta Ayurvedic Medical College versus Union of India, which was writ petition number 16296 of 2024, decided on 9th July 24. To submit that in the similar set of circumstances, the court granted relief to the petitioner. Paragraph. Without entering into merits and without expressing anything on merits of the case of the petitioner, particularly in view of the decision of this court in Achyuta Ayurvedic Medical College Supra, and further in view that having regard that the petitioners have undergone the studies and the exam is ensuing to be taken, and the exam is to be taken, first year final exam, and the first year final examination is to be taken on 15th July 24 onwards. There shall be notice to the respondents. Paragraph. By of ad interim leave, it is directed that the petitioner shall be permitted to take the examinations with clarification that permission granted by this court, as well as the spectrum of the petitioner's appearance in the examination, shall not create any right or equity in their favor, and that the respondent shall not publish the result of the petitioners without permission of the court. Service by hand. What is called here? And delivery is permitted. Office of access are dispensed. पहले लिख।
$84.
Learned senior counsel is on its legs, is coming.
Then we take up on some other matter. Let us.
Yes, please, madam.
Have it on Monday. Today, there is some inconvenience for the.
My lord, we will conclude our part. We may take about, we'll conclude our matter by about 10 minutes we may take, my lord. We'll conclude by citing certain citations, we'll conclude it.
Monday, Tuesday, 18th, 19th, whenever you want.
That's.
Last kindly have it on 19.
No,
19?
my humble request is, if it is
Don't-
on
you want-
Monday,
You want 15?
my lord,
Do you want 15 or 19? Tell us.
19th. Tuesday, at 2:30 it can be listed, my lord. At 2:30 and 19th it can be listed, my lord.
No, 2:30 we are not getting.
My lord,
We
my,
are in the middle of the hearing. It will taken up.
my lord, it's a part-head matter, my lord. Part-head.
What part?
On
Everything.
the other day, substantial argument we have concluded, my lord.
Hearted, all fully heard.
No, fully heard, my lord, fully heard.
Fully heard. So which date? That is the only question. Monday or 19th?
Have it on 19.
My learned senior counsel on 19th is not available. He is requesting on 20th, my lord, 20th.
20th, nobody will come. Unless you come, welcome. We will come. Let it be on.
Next door.
Sir, 22nd can be, sir,
18th is
Monday.
okay. Some matter is.
Saturday.
18th and 19th, lot of matter.
If it is on 18th, it can be. 18th it can be, my lord.
Your term is expiring in November.
And November 14th, hardly I have about 110 days only.
110 days.
110 days I may be in the office.
Take 110 days to argue.
No, my tenure of office, my lord.
Then
And the other day I demonstrated about the malifides of these officers. Because change of government is resulting me to disqualify me.
best date is 24th of July. Or we can have on, but it will be difficult to take up.
No, sir, 20.
As my lord, please.
24th July, so that we can effectively take up. That is the idea.
Please, my lord, please, my lord. Again, my request is
Before July 2:30.
2:30, ma. Then I am available.
Why everybody prefers 2:30?
Well, because,
2:30 is
no,
auspicious.
my lord is overburdened with work because of that thing, only accommodation we are asking.
2:30 is auspicious time.
It's not. We are also looking at the way in which overburdened work and also the everyone is.
We are never burdened.
Please, my lord,
Yes.
please. I'm
Number
obliged, my lord.
85. So NB and Swami.
I understand the government is seized of the matter. It can be called after 4 weeks. I'll be
That's-
granted the relief.
Could be called after.
I appear for the first
There's a
respondent.
vacancy.
Let's.
According to the director himself has written to the government for sanction, and it is pending with the government. They want 4 weeks. After 4 weeks, it can be.
It's 4 weeks
Taken up.
time. This
4
is with respect to backlog, my lords, filling up of backlog vacancies.
4 weeks.
4 weeks. 2nd August.
Number 86.
4 weeks will be. 11th, 12th.
ನಿಮ್ದೇನಾ ಹಂಗೆಲ್ಲ ನಾವೇನು ಹೇಳೋದು ಬೇಡವಾ ನಾವೇನು ಹೇಳೋದು
86.
ಚೌಟ್ರಲ್ಲ ಆರಂಭ
80. Nothing. 56. What is it? Yeah.
ಇವರು ಈಗ ನಮ್ಮ ಸಪೋರ್ಟ್ ಮಾಡಿದ್ರೆ ಅವ್ರಿಗೆ she is backing.
Will cost is still.
Third matter, first matter.
What that's right?
First year,
Please, madam. There are two matters by the public and one matter by the municipality, my lords. In the first,
This Ancient Monuments Archaeological Sites Act, that is the WP 31/676 of 2017. Where the construction of the market building by the municipality has come to a standstill on the ground that it is within construction of the.
please, in that matter, my lord, there are two aspects. One is that ancient monuments, it's coming within the protected area. Therefore, my lord, this honorable court granted an interim order, my lord, after seeing the report that it comes within that 190 meters. In that second writ petition, my lords, by another public spirited person, my lords, on the about the violation of the Karnataka transparency in public procurements. Rule 17 provides for a time limit, etc. Within the time limit, my lords, no tender was submitted.
90-meter aspect is in which petition? 4829?
4829, my lord, second one. 4829.
It involves the aspect of this proposed market.
Same market, tender, about the tender, my lords, being invited for the construction of the market building.
So this proposed market is proposed to be located within 190 meters.
Please, that 190 meters is one question, my lords. Therefore, is prohibited. Second question is the way in which.
This one question is in both petition or one petition?
First petition, that question regarding the 190 meters. In the
other-
second petition, my lord, the question is regarding the way in which the municipality called for the tender. Tender was called with giving about 27 days time. Though the law prevailing at that time demanded 60 days minimum because it was more than 2 crores. Last date was 20th January.
But that is not mandatory. We have all held.
No, my lords, that's
Not
after the amendments. That's the period prescribed is mandatory. Period, they can shorten the period, my lords. Rule 17 is mandatory.
Providing reasons.
The time limit, my lords, of publication, inviting the tenders, the time required, Rule 17. It can be shortened, my lords, by a superior authority. That's what this honorable court laid down. It can be shortened. There was no such order to shorten the period, one thing. And within the period of 20th was January 20th was the period fixed. There was no tender by anybody. There was a bid by anybody.
There was no.
No bid. Then they say they received the bid much later. And there was no order by the concerned tender inviting authority to extend it. And some other authority says, I am now extending it. There's only one person came. Initial tender bid was 1 crore. Now I am.
So that issue may not survive. That issue may not survive because there is no bid received.
No, but finally they say this is the bid. This person has given the bid after the period. After the expiry of the period. And then they say.
Only one bidder.
Only one bidder. And therefore your lordship said called for the entire tender documents and
Clear this 190 meter aspect.
both
No, that 190 meters, my lord, is a case where there is within 100 meters is totally prohibited area, no construction came up.
In 100 meters.
It is beyond 100 meters, where, my lord, the authorities can consider our request. If there is any modification to be done, the authority can consider it under the provisions of the Ancient Monuments Act. We have already submitted before them, and we have already given a report also, an expert report by the National Heritage Committee, saying that it does not affect anyone, the building, monument is not affected by this report, my lord. That report we have produced along with our additional statement of objections. Additional statement of objection in WP 31676. This report is by the Heritage Impact Assessment Report we have given. By the INTAC, prepared by INTAC, which is an expert body. That is Indian National Trust for Art and Cultural Heritage. Where they say specifically that from this area monument is not visible at all.
At which page? Which page?
Yes, page, my lord, it starts from page 17 of the additional statement of objection. And relevant page is at page 70. Summary and recommendations. Additional statement of objection, page 1717 in WP 31676. It starts from page 15. The conclusions are found at page 70. Relevant portion 70.
Page?
Page 70.
No.
70. Or print page 56 in that report, bottom.
No, where is the report?
Well, that report is annexure R4 in our additional statement of objection, starts from page 15. Filed on 22/6/21. Respond number 7.
19, 2005.
Page 17, 117. Annexure R4, page 15 in the show. 15. Or you will also take the copy.
Same.
In there below that print page 56 at the bottom or ink page 70.
Print.
In that report.
Print page 56.
56 numbers are at the bottom print page. That it starts on 7.0 summary and recommendations.
This is report or thesis?
Yeah.
You submitted a
Intact.
thesis.
This is by a report by Intact, Indian National Trust for Art and Cultural Heritage.
Where we are interested in finding also, no report. Where is the finding?
Yes, findings, my lord, page 56, last but one para.
Yes.
It was found, your lordship got it. It was found during the heritage impact assessment that there will be no direct impact of the municipal market redevelopment works on the inner courtyard of the Chowters Palace, which is located at a distance of 190 meters from the market site. There is also no substantial impact on the historic setting of the regulated or prohibited area due to the project, because between the monument and the proposed G+8 market building and commercial complex, there are already a few residential and commercial buildings of the same height or more. Therefore, the overall project impact on the inner
You
courtyard
are
of the
appearing
Chowters.
for whom?
Pardon?
You are appearing from whom?
I am appearing for the contractor, municipality, my lord.
Which for ISI, Archaeological Survey of India.
I am appearing for the.
What do you say about,
My lord, that application has been considered, my lord.
what do you say about the report?
The report has been taken.
Report is favorable to the petition for favors this commercial construction. It favors construction.
My lord, report.
According to you, you are the authority.
Yes,
Archaeological Survey of India.
yes.
Whether this report favors the construction.
May one submission, my lord. This report was taken into consideration by virtue of an order passed by this honorable court, my lord. Then that order has been passed, and in the order, it is specifically mentioned that, my lord, post facto permission cannot be granted. The law contemplates that, my lord, before commencement of the construction, they are supposed to seek the permission.
We are not, we are asking a simple query.
Yes, ma'am.
This is your report.
Yes, ma'am.
Does
It is not my report.
Whose report?
It is their private report, ma'am.
No, it is a
Not called for
report
the-
by a
It is a private.
independent society.
Not by.
This honorable court also directed them on the basis of this report to examine it. They said, we will not examine it. You should have taken permission earlier. Now we are not in a position to examine. They do not even examine it. This is a report which is an independent society, which is meant for the, as a specialized body. I have given it to them, asking them to, you take your own opinion, you examine it yourself. They are refusing to examine. In fact, they asked us to get this report. This report is by a independent society, which is also aided by the government of India. It is known as page 16, Indian National Trust for Art and Cultural Heritage. They were asked to look into this by an order of this court, but they have refused. There is an order passed by this honorable court, page 109 of the same statement of objection.
What is 110? R6 alva.
Will Lordship may kindly see page 109 of the same statement.
They also relied on this, they have graded.
This order of the London single judge, my lords, passed at 109 by the Honorable London single judge.
So
It's,
this new building is at a different place.
my lord,
New building is being constructed at a different place.
earlier there was no such building at all.
No, no, earlier there was a market building.
building,
That
not
has
like-
been demolished
Please.
and tenders were called. We wanted to accommodate the vegetable vendors in that very same area where they were doing business.
Very same area, but now it is near to monument.
No, same area. Earlier also it was there. It is a reconstruction of the building.
Same reconstruction building
Recon,
at the same site.
Same site. Same site.
the word reconstruction is now defined under the act.
He is not appearing in that
No, I am
public
appearing
interest
in
petition.
both
He is
matter, I
only
am
challenging the
assisting both
tender.
my lord and friends, my lord, both the matters. Now, my lord, the two public PILs, my lords. My lord, reconstruction is now defined. If the number of floors or the area horizontally, vertically is more, it's not reconstruction, it's construction under the act. And this order, my lords, at R6108 is obtained by the, at the hands of the Honorable Learned Single Judge, my lords. That order's date, your lords may kindly appreciate, December 22nd, December 2020. By that time, this Honorable Division Bench was seized of the matter. There was already a writ petition and orders were passed by this Honorable Court, my lords. Kindly see the orders passed by this Honorable Court, especially the other orders.
This market building is being put up by the
It's
municipal.
by the
council.
municipality.
Municipal council.
Municipality it is being put up. And
earlier
they are, my lord, they are not taking any action against other buildings which are already there much earlier to the monument. There are about more than 100 buildings.
More than 300 buildings.
About 300 buildings are there.
Let there be a report by the ASI.
I have filed a.
Team of
David.
ASI, you constitute a team, will direct you to.
My lord, I have pursuant to an order passed by this honorable court, my lord. The application of the town municipal was considered, my lord. An order also has been passed, and I have also placed that particular order before this honorable court. The order is at page number 4 of my affidavit, my lord, dated 3rd August 2023.
What does it say?
My lord, they say that post facto, after putting up the construction or commencement of the construction, there is no provision in the act to grant the permission. And my lord.
No, we are now telling you
Yes, my lord.
that you constitute a team pursuant to a direction, 3-member team, and examine the.
That direction is there, my lord. They are refusing to follow that order. Kindly see that order. The direction is to examine the impact on the monument and thereafter take a decision. That they say, no, we'll not consider it because you already commenced the building.
I will just try to explain the difficulty, my lord. Earlier to
What order is
2010, my lord.
We understand that.
Yes, ma'am. Yes, ma'am. There is one particular penal provision, my lord, which comes in the way, that is section 30B of the act, my lord, which says that, my lord, if there is any construction is put up either in the regulated or prohibited area, we are supposed to initiate the penal action against such persons. And my lord, with reference to this particular case, my lord, already we have sought for the sanction also. That is one thing, my lord. We have initiated the proceedings against so many other buildings by virtue of that particular provision, my lord. And definitely, my lord, this is a public property, my lord. That particular property should not remain vacant, my lord. I understand, my lord. But this is.
We are not saying that. You may understand anything.
No,
Make
my-
your submission, Mr. Counsel,
No, my
not
submission.
anybody else's submission.
No, my submission is that, my lord.
If you want to construct, you construct, and we'll prohibit you.
No, I am not constructing, my
So what kind of submission you are making, Mr. Counsel? That property should not remain unconstructed. We are not saying that. Yes?
My lord, my only submission is that, my lord.
Are you representing ASI or somebody else?
I am representing ASI.
So please, confine your submission to your counsel.
Yes,
Your client.
Yes, ma'am. My submission is that, my lord, an order is already passed. That order is part of the affidavit, my lord, which I have already placed on record.
Which order is passed?
Pursuant to the direction issued by this honorable.
Namely?
That is page number 4 of the affidavit, my lord. My affidavit, 3rd August 2023. Don't have that one.
Where is that?
That affidavit I have filed on 4th August 2023. In 51844 of 2019, I have filed it, my lord.
August, 3rd August.
Direction was issued by this honorable court on 21st June 2023, my lord. 21st June 2023.
So section 20D3 is what?
Section 30B is with respect of penal provision, my lord. Section 20C is with respect of prohibition in the construction of regulated area as well as prohibited area, my lord. This particular section 20C was introduced in the year 2010, my lord. Earlier to 2010, my lord, there was no express provision, my lord. After 2010, my lord, what are the construction has to be put up within the regulated and prohibited area, they are supposed to seek the sanction of the National Monument Authority, my lord, that is NMA. In this instant case, my lord, without taking the permission, my lord, without obtaining the sanction, they commence the construction activity.
They have commenced the construction.
Yes, my lord. That particular activity of commencement, my lords can see in the application, which Learned Senior Counsel referred to, in that photograph they have produced. This is the construction status, my lord. And once the construction is commenced, we are not supposed to grant the permission. That is what we have mentioned, my lord.
So this court has directed you. How can you take such a defense? Knowing fully well that there is a provision in 20D3 and 20D4.
Yes, ma'am.
This court has passed order to require you to examine. Why can't you examine? Are you above the High Court? No. Where is the person who is constructing? You are the person who constructs.
Contractor.
Lords, I represent lords,
The contractor is constructing.
Who appears for contractor?
I represent.
So you started construction without anybody's
No, my lords,
No,
the
approval?
municipal authority, my lords, after my lords inviting tender, lords, I was awarded the contract. Thereafter, my lords, I have gone ahead with the construction activities. It is the municipal authority, my lords, which entrusted the work to me, my lords. Thereafter, I have gone ahead.
The municipality, my lord, started because PWD gave an.
For municipality.
I am appearing for the municipality because we started because.
And have some other site now.
No, PWD has given an endorsement, it is
Why
beyond
should the
200.
ASI be forced to, by the court to take a decision when you are constructing violation?
Lord,
And they have got the provision in their favor and the statute that if the construction started, they can't give permission.
Lord, it doesn't say so.
Justified in that.
It does not say so, my lord. This does not, the object of.
Although
this
we are
is-
taking them to task, they are justified.
Lord, the
You
object.
can't be given premium to your own misconduct of putting up construction without any permission. Please sit down.
Provision does not say.
Lord, the provision 20C, wherein we have to take up.
You find out different site.
There is no other place, my lord. This is, comes within Mudabidri town, it is already huge amounts have been spent for this construction. There is an expert report saying that it does not harm the monument. There are
Already-
nearly 300 buildings which have been constructed beyond which, for which no action has been taken by the authorities. Only for the municipal building, my lord, we are into problem.
For my lords, this query, my lord, other area. Now already everybody shifted to one area called Nehru Maidan, a vast area. They are accommodated nearby in 500 or 500
Building is
meters.
already
In
completed.
Nehru Maidan, everybody is accommodated.
Your lordship
They
has
say it's
kindly-
temporary, but it's a government property. It's in the-
20C, my lord, it does not say prior
Your-
permission.
Your party when this some private report was given,
No, I am not party, my lord.
you
I
are
am
not
not
party.
party.
You were called in at the time of inspection.
We had inspected, my lord, by virtue
No,
of.
the private report says that it is safe. But did you participate?
No,
in
my
that?
lord, I have not participated.
This, I may assist in this. Private report is private, not at all called by the ASI, my lord. Section 20C demands that the ASI should call for the report, not the private report. They themselves prepare a report and submit it later, my lord.
Sorry, we have not
No, no,
prepared the
it is,
report.
it is by private body,
We have
not section
prepared a
20C is
report.
very
It a
clear.
report by a government recognized independent body. And on that, my lord, the court issued direction that on the basis of this, please examine the impact on the monument. Now that court order, my lord, they are not complying with it, saying that it is only prior permission which has to be taken. The section does not use the word prior permission. The object is only to see that the monument is not in, if the report is, it does affects the.
I
affects
place
the
on my lord,
monument
the recent
in any way,
petition of the
let
Honorable
me drop
Supreme
the
Court,
project.
please. Honorable Supreme Court was clearly said, my lord, prior permission is required.
Section 17,
No.
where is section 7? Procurement.
Lordship may kindly see 20C.
Section 7 procurement it is. Rule 17, I beg to rely upon my lord. Rule 17, my lords.
The relevant
Rule
provision is
17,
section
now how the
20C.
contractor got this property, private property, my lord, clandestinely, your lordship may kindly see in the present.
No, that's a
As on
different
that,
issue.
no, that's it. No, municipality cannot speak for the contractor.
Issue
No,
is with
your lordship,
regard-
how?
No, 1 second. Issue is with regard.
Minimum time for submission of.
Prior permission.
That is now amended. My
Tender-
lord, when the
tender-
tender was called,
Kindly listen. Tender which was invited, give only 27 days.
yes, it can be given.
What is required? 30 days,
No, my lord, at
60
that
days.
time, 60 days.
60 days.
At that time, 60 days.
So that was mandatory.
That was mandatory, my lord.
Except,
None, my lord. The
except-
total value of the.
No
bid-
tender at all. No municipality
total
cannot
value
speak
of
for
the
both.
bid- Lord, first of all, a PIL is not.
100 crore
in a
property.
Tender matter. He is not an applicant. This PIL is sought to be filed in respect of a tender matter. He is not a rival tenderer. He is not.
I'm not a
person
rival tenderer.
aggrieved. Insofar as the tender proceedings
I-
is concerned,
Please,
now, my lord, the.
kindly
value
see
is
annexure A for a moment. Annexure A and B in my writ petition. This will speak for volumes how the
Completed,
property
I
of the
cannot.
government is taken. Kindly see annexure A. The value of the property is stated to be 25
Not value of
crores.
the property. It is
Now, my
based
lord,
on the
annexure-
leased amount.
With permission, please.
It is based on
Annexure
the
B is
leased
the
amount.
publication, public tender publication, 23rd December 2016. Last date mentioned is 20th January 2017. No application till last date. This is called by the municipality. And thereafterwards, my lords, 13/2/2017, they say we have received some hard copies of tender documents after this date, 13th. Then, my lord, Town Municipal Council writes, this is the objection raised, and this honorable court called for the reports. At that time, respondent number to municipality produces a document styled as R1. This is dated 4th February 2017, issued by Karnataka Water and Sanitation. Now, my lord,
Where is that photograph? Photograph showing construction,
photograph showing constructions annexure R4 in this case, my lords.
extent of construction.
Extent. R4 is a construction in this case, R4 in this case, my lords. And that's after the filing of the writ petition. This honorable court initially said any construction is subject to the orders of the court. Then this honorable court restrained them from putting up construction. There was no bid by anybody till 20th January. Then, my lord, is one entity called Karnataka Water and Sanitation Pooled Fund.
He was the only bidder.
He was the only bidder, and some entity says, I am going to extend it. And that entity says, I am also reducing that 1 crore to 25 lakhs now.
He was he was awarded the work.
Yes, yes. He was unilaterally awarded the work by the municipality. One pooled fund says, I am going to extend it. This is unknown to law. That's why we have come up. The prime land, my lords, is given to a private entity for construction of this one. And they say, you collect the amount and you give this much to us. They say you collect the entire rent from others and you give 1 crore per year. And total construction value is 24 crores. Now the argument advanced before this one, when this one court asked at the initial stage, the value is more 25 crores. How can you do this? Then the answer was, the value that construction value should not be taken despite annexure A, the report. They say now, subsequently, the rental value is 1 crore. So please consider 1 crore. Therefore, we can make it 27 days. And what about this received after 20th? What is the authority? Then they said the pooled fund is there. That
What is 1 crore?
they say after the tender, they say highest bidder is this person and annual rental value he's giving is 1 crore to the municipality.
So it comes within 30.
Therefore, they say, don't consider the construction value of the building. Though we said so in Annexure A, they themselves said this is the construction value. Please consider 1 crore as the value, which they come to realize it later. And they say, therefore, and then a question. How the public property is, my lord, swindled in this manner? And which is this pooled fund, this authority, my lord, nothing to do, some fund of the government of Karnataka trust, they say, we are extending the time. Who are they to extend it? They extend it, and not only extend, they say, if EMD, initially we stipulated 1.25 crores. Now we feel that 25 lakh is sufficient, therefore reducing it. This is all unilaterally, they reduce it. So one person goes, this 25 lakhs, I am giving now 25 lakhs, and
Original tender was of vote value.
Pardon me, my lords.
There was reduced.
Yes, tender bid amount was, EMD was 1.25 crores. They reduce it to 25 lakhs unilaterally.
So it will attract 60 days.
Both are, everything is violated. 60 days time is violated. Your lordship question, 60 days.
Since tender was for 1.25 crores.
Tender was for 25 crores.
25.
Yes, tender was for 25 crores because
25
estimated value of the construction of the building is 25 crores.
Therefore, the time limit was 60 days.
It was 60 days, my lords.
Because of that limit of 25 crores.
25
Beyond
crores.
2 crores.
Yes.
So what happened thereafter?
Thereafterwards was no tender was received within 20th January. They give only 27 days in the initial publication. There was no tender issued, no bid submitted by anybody. So on 4th February, a letter is issued by an entity called Karnataka Water and Sanitation Pooled Fund, R1, saying that earlier we said the EMD must be 1.25. Now we are reducing it to 25 lakhs. And we are also extending the time for submission of tender to 13th February. They themselves extend it, and then they eventually they say, we don't have all the documents. That's why this all got called for the tender. Now they say one person has come with this 25 lakhs, and then they enter into the this one, my lords, bargain, how much you are going to pay. And that person says, I'm going to pay 1 crore.
They extended the time by writing to them.
Writing to, we do.
By giving advertisement.
No advertisement is given.
No advertisement.
It's a private communication between the Karnataka Water and Sanitation Pooled Fund. I pray R1, your lords may kindly see R1, which they have produced. R1. Pooled fund, which they say is a trust. And its letter is issued to Manager Center for E-Governance. No publication.
Who are you?
I am the public spirited person. Both cases.
We know.
My lords, one is my lords, editor in the first case, and the contract is so powerful at one point of time. When this only court granted an interim order in the first case, immediately the contractor came and said to the court, oh, AMD 0 na? Huh? Oh, further unta. ಹೌದು. Oh, EMD 0 ಆಯ್ತಾ? ನೋಡಿ ನೋಡಿ. One more thing, my lord, very interesting. Now I find they said it should have been 25 lakhs, but now we feel it's 0. It should be 0. They make it 0. Kindly R1, my lords. In the bottom say, now EMD is made as 0. EMD is now made as 0. Initially 1.25, then 25 lakhs, then it is made 0. How it can be made 0? Your lordship may kindly see. It is mentioned to effect changes following modification. EMD has to be effected in the system R1. That's your document. I don't have anything. R1. They say EMD is now made 0. Last button para. Above modification can be made. Issues will be sorted up. We will be able to proceed in the matter. And this tender is given. Our only prayer is, my lord, let a tender be called for in accordance with the law. Let there be the best bidders. And let the ASI also look into this matter. And this illegally obtained, my lords, a public property, there is a trust doctrine, public trust doctrine, my lords. The municipality cannot give away the entire property to, at his whim and fancy, to a third party by violating all the provisions of law and no equity in their favor. Now the TMC, the municipality is a hand in glove with this tenderer. Where is the documents we have produced?
Where is that ASI? Where is your order? Where is your order you are pointing out?
Yes, my lord. Affidavit, my lord. Affidavit dated 3/8/2023.
No, yes, yes.
EMD, correct alva? 0. MD 0. Huh? They have produced it.
ಈ ಕೇಸ್ ಕೊಟ್ಟು ಕೇಳ್ತಾರೆ ಆ ಕೇಸ್
ಒಂದು ನಿಮಿಷ. Supreme Court ಕೊಟ್ರಾ? On that section 20 implications, my lord, the decision of the Honorable Supreme Court. ಕೊಟ್ಟೋಣ, ನಮ್ ಕಪ್ ಕೊಡಿ. ತಗೊಳ್ಳಿ.
We would pass some order on 24th. We are inclined prima facie subject to further consideration to require you to examine it, whether it is feasible or it is damaging to the structure. We'll just find out sometime. And we are going to take to task the contract. Where you have conducted it.
He cannot be the beneficiary of the illegality. May I pass on the Supreme Court decision? He said reconstruction, my lords.
No, his
Cannot be done.
statement is wrong.
This I may beg to.
The value is, I will be able to answer all his points. He is factually incorrect. So far as the tender document is concerned, the tender document condition itself says in what manner it should be evaluated. Municipality is not spending the money. It is on the basis of build, operate and transfer.
It's a huge market.
No, yes, it is a case, my lord, where the contractor
Property value is
will bid
100
out of
crores.
his own funds, out of his own municipal, not municipality's funds. He will have to give lease rent to us.
Everybody will be ready to get it.
It is not a case where I am,
Like a mall in a metro city.
Yes.
it is in the case of annual lease rent, my lord, on that basis it is.
In your lease
evaluated.
rent earning will be 50
And
crores.
how?
They are paying 1 crore to the municipality. Everybody will
What I
come.
said in a tender matter.
That's
my
why
lord,
it's secretly
question of
done. Everything is done secretly.
Not arise.
We'll see what to do on 24th.
Please, may I pass on those decisions on Supreme Court on this point, my lords? Please, with kind permission.
Eighty-one, my lords.
Pardon?
Serial number 81, my lords. 81, my lord. Hearing before charge. My lord, 85 years, my lord, they are all into pension matter. They are not compliant with hearing before charge. They are all above 85 now, my lord, nearing 87, they are like that.
Contempt.
The tender.
Pension, they are not- Contempt matter, my lord, hearing before 81, my lord. A short date, my lord, it was
August,
Ask-
2nd August.
2:30, my lord, any date, my lord.
Now we will sit from tomorrow 2:30 only. No sitting at 11.
Only regarding to their age, my lords.
24.
Regarding to their
So
age.
all matters will be taken at 2:30.
ಅಲ್ಲ, one short date, my lord.
Pollution Control Board matter. Sorry, but
ಹೇಳಿದ್ರೆ ಮತ್ತೆ ಹೌದಾ?
That is the only date possible. That is the only date possible. Earliest is 18. Lot of matters are there.
We'll take a chance, because I partially completed. The number of days are also short.
Date ಕೊಟ್ರ ನಗ್ಬಿಟ್ರು, ಹಾ.
We decided.
Who is Europe?
AG is there. AG is always there.
If you convene to AG, then keep it 19th, but we are not sure whether. A lot of matters are fixed on 19th.
Absent, but what has happened, Lord, is time is short. That's it.
Time is not November, your term is expired.
Yes, but still, Lord, I can complete in 10 minutes.
Very good,
Then ADS.
very good. So inform the AG. If you convene to AG, then
Yes,
both
we'll
you
inform.
common request, then My lord,
My lord, serial number six.
Your lordship, my lord, short date, my lord, 81. Short date, my lord, 81, my lord, 81.
Serial number 79, I am for respondent, my lord. Will it obtain interim order, my lord? The matter is posting for 6 times, they have not completed the application. Any condition order, my lord, falls to the applied, apply the application. You obtain the interim order, not ready to complete the application.
My lord, Master will read. Yes,
My lord,
any-
serial number 16, my lord, fresh matter, my lord, the metro work is stopped, my lord, kindly have it on next Monday or Tuesday. Serial number 16, my lord,
891, 830.
Monday or Tuesday, my lord.
Whenever you want. Give
Monday.
it.
Monday.
Party is ready to settle the matter, kindly refer to local.
On 18th will, 18th. 18th at 2:30.
Serial number 58, my lord.
Lok Adalat, 13th Lok Adalat.
36.
So then let's place it at the request of learned counsels for the both the parties. Comma. As per request of learned counsel for both the sides. Other side is also agreeable. Comma, the matter may be placed before the Lok Adalat to be held on 13th of tomorrow, day after tomorrow. Who is other side? So somebody is there. Who is there? Who is the counsel? Who have taken consent? So why don't you pass on the memo, joint memo? Tomorrow you may pass. You do it. Keep it tomorrow and tomorrow this will all be, this order will.
Serial number 58, my lord, that batch matter, minimum wages, my lord. Minimum wages matter. May be taken up next week, my lord.
Serial number
On
20,
18th, my lord.
No, 18th.
my lord, serial number 23, contempt matter, my lords. It's been a year, they have not complied with they have not filed a compliance affidavit. There's extreme urgency. There's a bill amount due more than 1 crore. Now complainants are civil engineers and they have taken loans and completed the executed works. Kindly, there's an urgency in the matter. May I have it, may I have a shorter date for it?
Which date?
Please, my lord.
Which date do you want?
Any date next week would be
Tell the date.
Monday, my lords, Monday.
My lord, serial number 21, my lord.
56 minutes.